treatment.
You just want to be like me.
That's what I'm saying. Like,
It didn't
I
take
promise
long
you, I
either.
wouldn't wish this on anybody.
I know.
Just do. That style shirt's perfect for you then, because you'll never see it.
That's my golfing shirt.
Exactly. You'll never see it.
You just reminded me.
Don't see the intervener.
Get out early.
Yeah.
See, I don't see the intervener yet, but it is the second application. So.
He talked to him on the phone.
Okay, well, it's not the first application anyway.
Pretty cool. Yeah, these coffee hammers
Might be.
also in Daytona. Doing this thing.
I do.
Live.
Oh, it's that vanilla horchata coffee.
Is your applicant here?
I don't know how I feel about it.
That's her.
Do you have a doorbell?
That's why you gotta just stick with black.
You can talk through it.
Joanna, we did that.
I go, hey,
Why won't you come
right now, what you need?
This is the Citrus County Planning and Development Commission public hearing for August 20th, 2026. If you would like to join us at this time, I invite you to please stand for the invocation and remain standing for the Pledge of Allegiance.
Dear Lord, please give us the grace to be understanding, patient, and tolerant. With these attributes, we can conduct our work in a manner which will be pleasing to Thee, our county, and its residents. In the Lord's name, amen.
For the courtesy of the applicants, the board, and those around you, at this time, please place all cellular devices and any other devices you may have on mute. Roll call.
All right. Good morning. The following Planning and Development Commission members are present. Chair David Bramblett, Michael Facemeyer, Second Vice Chair, Richard Barmez, Stuart Bozeman, Robert Shera, alternates Timothy Gilbert and Janice Murphy, and School Board Representative Chuck Dixon.
Thank you. If any person decides to appeal any decision made by the commission with respect to any matter considered at this hearing, he or she will need a record of the proceedings. For such a purpose, he or she may need to ensure that a verbatim record of the proceedings is made, which record includes testimony and evidence upon which the appeal is to be based. During the public input portions of the meeting, individuals are given 3 minutes and representatives of an organization are given 5. When anyone wishing to speak comes to the podium, please complete a yellow form and hand it to this recording secretary. Please print your name, address, and the number of the application for which you are speaking on the form. The yellow forms are at the podium by the door. If representing an organization, a letter of authorization must accompany the speaker. Comments will be limited to the topic being heard. Please state your name, spell your last name, and give your address for the taped record. At this time, we're going to have the public portion of the meeting. This is an opportunity to come forward and address the commission on any issues that you may wish. This is not for any of the applications. We have 2 applications being heard today. You will have a public input portion for each of those. If anyone has anything that they would like to come and discuss in front of the commission now, the podium is open. Seeing none, we'll close that portion of the meeting. We do have minutes from July 2nd, 2026.
Mr. Chairman, I move we approve the minutes of July 2nd, 2026. As
Second.
We have a motion to approve the minutes from Mr. Facemeyer with a second by Mr. Gilbert. Is there any discussion? All in favor?
Aye.
Opposed? Motion approved. Ms. Coutu?
Mr. Landon, you have anything to address the board?
I'll give some updates on a couple of items once we conclude on data center ordinance and the county comp plan.
At the end of the meeting?
Yeah.
Nothing else, thank you.
Anything else? Thank you. Ms. Lynn?
Yes, with regard to the applications on the agenda today, have you had any ex parte communications? And we'll start with Mr. Dixon.
Site visits and emails about the Betts Farm application that I received.
None.
Site visits and emails.
Site visits and emails on the Betts Farm.
No site visit, but yes with the emails.
Site visits and emails on Betts Farm.
Just the emails on Betts Farm.
Thank you, Mr. Chair.
The emails on, is that quasi judicial? I mean, we don't respond to those, but we've been getting emails from the public recently. That's changed because they used to all come through the county, but now we're getting them like directly, but we don't respond. Is that communication?
I appreciate that you don't respond. That's not true for everyone. But if you get an email, you're supposed to forward it to Joanna so that she can make it part of the record. Most of the time, the emails that you get, she gets as well. So if you see that Joanna's copied or if you see that I'm copied, I make sure that whenever I get one, I send it to Joanna, and then Joanna always makes sure that what she gets is put in the record. So if you get any, just if you don't see her name or my name up there, then just forward them to her. Sometimes commissioners write back and they say various things like, thank you for your input. Sometimes they say things like, thank you, we'll consider all the evidence when we're in the hearing. So some commissioners do respond, both at this level and at the BOCC level.
Thank you.
Thank you. At this time, we'll hear application V-2026-00006. Is the applicant present?
We're not sure they are. Doesn't look like it.
So the
Sign?
The sign variance, their application is not, no applicants present for Thomas Signs? That would be no.
okay.
You want to hear it or?
I mean, I guess we can do the staff presentation, and then maybe they'll show up, or we can hear from Ms. Hoover and
Up to you.
give them a few minutes.
We have not heard that.
The mouse is a floater, so.
Are we having technical difficulties?
I
Okay.
know I'm having technical.
I thought you logged in like 5 minutes ago.
Alrighty, it won't go. This is V2026-00006.
Pull your mic
Thomas
towards you.
Signs for Village Power Sports and Marine. This application is for a variance to allow for additional signage. This is an aerial view of the subject property. A picture of the subject property. Looking north from the subject property. Looking south from the subject property. Looking east abutting residential. Looking west from the subject property. And this is the approved site plan. Thank you.
Thank you. So nobody's heard from anyone regarding this particular application, correct?
No, Melissa, you haven't heard from the applicant on this, but she can do her presentation if you'd like.
Sure. Maybe they'll come in.
Mr. Chair, sorry for the interruption. But if we hear the staff report prior to the application or the applicant and the applicant does not show up, does that give us the remedy or the permission to go ahead and vote on the application?
I would defer to staff or county attorney.
Yes,
So we will not be able to vote, or we will be able to vote?
you will be able to vote.
Okay, great, thank you. I
It's-
just didn't
it's
want to
noted-
waste anybody's time by listening if we're not going to be able to make an accurate or correct vote. Thank you.
If you choose to make a decision, you can choose to make a decision, or if you want to continue it, you can continue it. That's
Thank you.
to the board.
Thank you for the clarification. My apologies.
right, so this variance request is for additional wall signage on a commercial building to exceed the maximum wall signage allowed by the LDC, which is 1.5 times the linear frontage of the building. This is a photo of the 4 permitted signs that nearly reach the maximum allowed for the building. Maximum allowed is 147 square foot. They have these 4 signs are 140.59 square feet. And this is one of the signs that they are requesting. It has been installed without a permit. This is one of the 36 square foot signs. They're wanting to add a second 36 square foot sign underneath this one. They also do have some flag signage. Those are actually not permitted in the LDC. Upon site visit, I did notice some deviations from the approved site plan. They have vehicles stored in the required parking, vehicles stored in handicap parking, vehicles stored in the required loading zone. There are some vehicles in the right-of-way which are not permitted. Some more vehicles parked where they're not. The most concerning thing upon site visit was the unpermitted storage areas. This property is in the coastal high hazard area. It is also in a flood zone. By adding this unpermitted storage area, they have exceeded the maximum allowed ISR. So that's quite a deviation from the approved site plan. This was originally permitted in 2022. Today, this would require a PUD because of the coastal high hazard area and the use. So exceeding ISR is very concerning. This is the approved site plan. You can see where it says Bahia Sod. That is all supposed to be left open for pervious area, and it is being used as storage and vehicle storage. This is just an aerial view of the property. Again, the approved site plan. There is no hardship for granting this variance, and by granting the variance, you would grant the applicant special privileges that are not allowed to other businesses. And that's all I have, unless you have any questions.
Any questions from the board? Yes, sir.
Have we made effort to bring them into compliance on some of these matters that they're out of compliance on already?
We have not, but you can choose to do that at this hearing.
Okay. That's all I got.
Anyone else?
Mr. Chair.
Mr. Facemeyer?
What triggered the application? It seems as though the applicant disregarded any of the regulations that the county has in place, and now they wanted they placed an unpermitted sign and want to place another one. What made them decide at that point that they needed to come seek approval from the county?
So they did apply for a permit for the 2 additional signs. That permit was denied because it exceeded the maximum signage allowed.
They put one up
They
anyway?
put one up anyway. The other sign is being stored in a parking space.
And in your research, you found these other unpermitted uses when you did a site inspection?
Correct. Ms. Katu and I both did a site visit and found all this deviations from the approved site plan.
Did the applicant or the applicant's representative indicate that they would work to come into compliance, or
They did not,
just indifferent? They didn't say one way or the other?
one way or the other.
Okay, thank you.
I don't think this mic is like cutting in and out, but anyway, so you said regarding the additional deviations that they are, the impervious surface area, which is grass, but they're parking on it,
Correct.
which is a deviation.
They've also added a fence in that area and are storing additional items in there other than vehicles.
Right. So we as a board, what mechanism do we have? I mean, the rule is already in place. Like they're deviating from what was already established. So what do we say? Oh, you're in trouble for doing that, or I mean, there's not a whole lot that we have as a mechanism as a board, right? We can say you weren't supposed to do that, so shame on you. We're not going to grant you your variance for your sign, and you need to clean all this up. That's pretty much all we're left with, right?
As a board, you can actually refer this to code compliance, and we can start that procedure with these other items, not only the sign, but the other items, and that's
Okay.
up to you.
Yeah, so we as a board would say, okay, we whatever the vote may be on the sign variance, and then as a side note, we're also going to refer this to the code compliance.
Right, on the sign or the other items or both. It's up to you.
Okay, so we would just discuss that as a board because I've been a member of this board for quite some time, and I don't know that we've ever done that.
You have.
We have? Okay.
You may.
Yes, ma'am.
Mr. Chair, so with code compliance complaints, the board, or excuse me, the county does not accept anonymous complaints. So oftentimes you'll see either commissioners get contacted by their constituents and they'll file the code compliance complaints, or as a board they do, and as a board you can.
Okay. All right, thank you.
Thank you.
We've had some people walk in. Was any of those the applicant for this application? No? Okay. We'll have the public portion of this meeting. Before we open the public portion of the meeting, I want to take a quick second to talk neighbor to neighbor about who is sitting up here today. For those that are in attendance and those on YouTube, we would like to help educate the public and those watching live. In my experience, I've noticed a lot of confusion and angst as a result of a lack of understanding of the dynamics of the people you see sitting here in front of you today. Everyone you see on this board is a volunteer. We aren't here for a paycheck. We're here because the BOCC asked us to serve 4-year terms to look out for the people of Citrus County, our friends, our families, and our neighbors. The BOCC appointed this cross-section of individuals purposely to ensure all aspects of the public domain were represented. We've got real estate brokers, builders, engineers, HOA presidents, and planners, to name a few. Like you, we all live, work, and play right here, and we love this county deeply. I know there is a common worry that boards like this just rubber stamp every request that comes through, but I want to promise you that isn't how we operate. We are a well-qualified group that puts a lot of cerebral energy and careful thought into every single topic on this agenda because we know that these decisions shape the future of our home. We are here to represent you, and we take that responsibility to heart. With that said, we'll open the public portion of the meeting for variance V-2026-00006.
Good morning,
Yes,
gentlemen
ma'am.
and ladies. PJ Offhammer, Citrus County. Just a quick thing about the code enforcement. I would urge you to refer this. It's time that we start requiring businesses to follow the rules. Too many times they get away with it because nobody reports it, or they think that they can ask for forgiveness rather than permission. It's time we start taking a stand and making our community a better place. And if you are not willing to submit this on your own terms, feel free to use my name. I can be the complainant. Seriously, my neighborhood went through this where we had, we still have ongoing code complaints. The problem is that they have connections in this county that have allowed them to get things that they don't deserve. But I think this is one that could be fixed. And it's probably not your purview, but I think we need to be looking at the code enforcement and how we do things when people are in violation and allowing them to continue or not stop what they're doing while they have applications in place. So just my 2 cents. Thank you very much.
Thank you. Anyone else? Last call. We'll close the public portion of the meeting. Bring it back to the board for discussions, motions.
Mr. Chair,
Mr. Shera.
for purpose of a motion, and I am assuming that we are looking at variance approved with conditions, approved or denied. Is that correct, Madam Attorney? Page 2 of 3.
The variance motion.
Variance motion. Thank you. The Planning and Development Commission finds application number V-2026-0006 inconsistent with the Citrus County Land Development Code and is not in keeping with the intent of the policies of the Citrus County Comprehensive Plan, and that the board denies the application based on the evidence and testimony presented in the staff report and conclusions regarding this petition.
Second that.
Go ahead, you got it.
And, Mr. Chairman, I'd also like to add, with Commissioner Shaw's consent, a note that says we will refer this, the deviations to code compliance for remediation.
Agreed.
We have a motion and a second, first by Mr. Shera for denial and a second by Mr. Facemeyer with the code compliance recommendation. Is there any other discussion?
Mr.
Mr.
Chair.
Barmez.
I'd just like to add, I'm not in favor of this application at all. I am in favor of the code violations. I believe there's a lack of responsibility from them for not showing up, and lack of responsibility for them not to comply with the law and the previous application permit that they done, and they extended it to on their own behalf. So just want to get on the record, that is why I'm not in favor.
Thank you, sir. Anyone else?
Yes.
Yes, sir.
I'm also strongly opposed to this for several reasons, and them not showing up is not one of them. Something could have happened on the way. But blatantly violate existing codes is disappointing that they would do that, and even more disappointing that action's not been taken yet. Of course, it requires somebody to notify, so I believe what we're doing here today is hereby notifying as the Planning and Development Commission that we want to refer this to the code compliance people in the strongest terms.
Yes, sir. Anyone else?
I'm in agreement with them.
Yes, ma'am. Anyone else? I would just follow up with what everyone else said. I've been beating the drum for a lot of these businesses that are all around the county. Being on this board as long as I have, I kind of know the things that you are allowed to do and you're not allowed to do. And there's a lot of businesses out there that are doing things that they're not supposed to do. And then businesses come before us to do the proper thing and get permitted, and we tell them that they can't do the things that people are currently out there doing. And I think it's unfair to those businesses. So with that said, if there's no final discussion or questions, we'll take a vote. All in favor?
Aye.
Opposed? Motion carries unanimously.
What's the base? My computer's not coming.
Yeah, it's actually kind of slow.
Want to borrow Joe's for
I
the,
can't.
you want to borrow this
Oh,
one?
wait, maybe this time? No.
Joe doesn't need his for this application.
May I?
Yeah, absolutely. Where's the mouse?
He's got the intervener up there, but
You got a right hand, Jim.
you shouldn't have a hand to do the mouse anyway.
I can do it backwards.
Okay, at this time we will hear PUD-2733. The applicant is present. I see Ms. Hoover.
I'm sorry, Mr. Chair, we have an intervener application on this application that's the first thing you all have to decide is whether or not you're going to allow an intervener.
So is that a full discussion with a motion and a vote?
It's a motion and a vote, yes, sir.
Okay.
As to whether or not, hopefully, I can't see mine, but in your package, you'll see the intervener application.
Yeah, I read it. Is the intervener present?
I don't see him yet.
Is a representative of the intervener present?
Ma'am, I'm sorry, if you could go to the microphone, please. Oh, you're fine. Just state your name and address and.
Angela Lukasik, 5427 North Sierra Vista Drive in Crystal River. My husband and I hired Michael Hill to be the intervener today, and he is in Denellen right now, speeding as fast as he can to get here. That's
okay.
Is he on the way?
Yeah, he's on the way. Correct.
he's on his way.
Speeding. I thought she
Speeding.
said speaking, but I think
He's speeding right now as fast as he can. Hopefully, he won't get a ticket.
So would the intervener speak first? before
No.
the applicant?
No, the intervener speaks. The process. Well, first you have to first you deal with this, then you deal with the letter requesting the continuance. Then you deal with, and then the applicant goes, and then the staff, and then the intervener.
Okay, so we have time, I would say.
First, you have to rule on it.
Right, so I'm bringing it to the board for discussions and a motion on the intervener status.
Mr. Chair,
Mr. Scherer.
for the purpose of a discussion, I've read the letter of requesting the intervener participate. And in the past, in my experience, we've accepted all interveners. When I read this letter, however, it doesn't seem that they meet a test of having an extraordinary impact on them personally or the organization they represent beyond a normal citizen. And the issues raised are valid. I understand them. But does that rise to the level of an intervener? So is there any test that needs to be applied? And if not, then I'm just looking for clarification.
Ms. Lynn, may I speak on this matter?
Are you the applicant?
I'm the attorney for the applicant.
I would hear what you have to say regarding this, only on the intervener situation.
Sure. No, I'll confine my remarks to the intervener situation. We do plan to go forward today, by the way, because since I'm speaking to this, we don't plan on asking for continuance. I have to roll that in because we're now proceeding with the meeting. But
I'm sorry, did you introduce yourself?
yeah, Daryl McAteer, 100 East Henderson Boulevard. Sorry, 3314 East Henderson Boulevard, Suite 100E. This went in a little bit different order than I initially expected. So I'm the attorney for Bravo Land Group, LLC, on this matter. We're not going to request a continuance, so we're prepared to move forward today. We have the shadow of that case decision. We can talk about that later. It is true that I am used to what the gentleman just stated is someone having an interest in the matter greater than the community at large. That's generally the standard. I didn't see that in the application either. It's a bunch of one-lines to get a consultant in. That's not typically the role of an intervener. So, we weren't planning on objecting to the intervener, honestly, because we have rebuttal. We were just going to roll it into Mr. Pidgeon's testimony. But he doesn't, we've seen no proof. The intervener's not here, and we've seen no proof that this person rises to that threshold. And so I have to get out here and do my job and tell you that I don't think they meet that standard. It's not an intervener I would bring forward if I was on the other side of this thing. I'd get somebody a little bit more involved. But if it's your judgment whether it meets the standard or not. I don't think it does, but we were going to just rebut him anyway.
Thank you.
Right.
So back to the general discussion. In the past, in my experience, whether it was the data center or previous projects, we've accepted intervener status. And the points that they make in their application or their letter of interest are valid points. I don't have any particular reason not to accept them as an intervener. I just don't know what rights that gives to the intervener in terms of this process other than cross-examination. If it's a matter of providing them 30 minutes to present the case, their particular position, and to cross-examine the applicant and the county to bring out additional information, I would support that.
Anyone else have any input? Okay. Does anyone want to make a motion for the intervener status?
Mr. Chair, I don't know which of the motions we would refer to here, but I would make a motion that we would accept as an intervener Mr. Hill and his presentation and testimony today.
I'll second that.
Mr. Chair, maybe a caveat might be that he's here with the woman that spoke. I'm sorry, I didn't catch her name. She said that he was here on her and her husband's behalf.
On their behalf, correct. So I would amend the motion that we would accept Mr. Hill as an intervener representing Citrus County residents who are in attendance today.
Any discussion regarding Mr. Scherer's first and my second regarding the interveners?
I'm sorry, Mr. Chair. May we get her name on the record? I'm sorry, I didn't catch her name. Carissa.
Yes, ma'am. Angela Lukasik.
Thank you. Can
Of
we make
Sierra
that part
Vista
of the,
Drive. Okay.
Can we make that part of the motion?
her address?
Her last name and her name, and just make that part of the motion that the interveners representing
Oh,
Ms. Lukasik.
Angela Lukasik is being represented by the intervener, Mr. Hill.
Correct. Make that part of the motion, Mr. Scherer's motion. You agree with that, Mr. Scherer?
Absolutely agree.
Okay.
And I'll make that part of the motion.
Okay, thank you. Anything else? I'm sorry.
Well, the application doesn't.
You need to be at the microphone first of all, Mr. McAteer.
Okay, well, we need to slow this down a little bit. Who's the intervener? Who's the representative? Who lives where? We haven't had that conversation yet. We're bringing in an expert from out of town and calling them an intervener because they somehow have an interest greater than the community at large. Is Michael Hill the intervener? Who's the intervener?
I
Lucas?
believe that we've established that the intervener, Ms. Lukasik, is being represented by Mr. Hill.
Okay, then Mr. Hill's not the intervener. Ms. Lucchese is, right?
Ms. Lukasik is the intervener being represented by Mr. Hill, is what I believe we've established on this board in this discussion today.
And I would remind Mr.
The
McAteer,
application
he's
doesn't
already.
reflect that.
May I? I would remind
May
Mr.
I?
McAteer that he's already said they don't have any objections to the intervener. So now is he saying that he has objections to the intervener?
I am, because we just changed the name of the intervener. The intervener on the application is not Michael Hill. Or is Michael, excuse me, it is Michael Hill. I've got to get it open to the right page because we're going in the wrong direction. But let's get the procedure right. If you're saying the intervener is Michael Hill, my understanding is Michael Hill is from Ocala somewhere, whatever. He's not an attorney. He's a witness. He's not the formal intervener. He doesn't meet any standard for an intervener. I have to do this. This is not the way I wanted to open the meeting, obviously. But you've got, usually what happens, you have a citizen intervener who has some sort of standing at large greater than the community at large. Okay, that's your intervener. Then they have a representative. That's fine. But you just said the opposite, as I understand it. So let's get that straight. Who's the intervener? And who applied as an intervener? And if they didn't meet the time requirements and everything else, it's not proper.
I believe that we've established that Ms. Lukasik is the intervener, and she has interest, and she's being represented by Mr. Hill.
I've got to go to the
That'd be
application
different than
now. Now I've got it
you-
open. The application to intervene, name print, Michael Hill, Torreya Design Consulting, Gainesville, Florida, excuse me. She's not on the intervention request.
So is the fact that there's been a application error created by the name, does that establish reasonable cause to eliminate the interveners?
The testimony before you today is from Ms. Lukasik. Mr. Hill is not even here yet.
Right.
So
Where's
she's-
Ms. Lukasik in the paperwork?
I'm sorry. You please not interrupt us. Thank you.
I'm going to represent my client. I have to do that. That's my job. That's my
You
sworn
don't
oath.
have to interrupt.
But you'll get an opportunity to speak. I've already given you one, okay? We're not trying to have some adversarial relationship and meeting here,
I
right?
just want this to be done right.
We're just talking it through.
The testimony before you today was from Ms. Lukasik, that she is intervening and that he is representing her. If there's some scrivener's error on the application or the application is deemed insufficient, then Ms. Lukasik can make her point to you today. Or you can deny the application for the intervener.
Right.
Those are your choices.
Yeah. So based on the follow-up discussion, Mr. Scherer, you were the first.
Does the scrivener's error deny Ms. Lukasik the right to be an intervener?
May I speak? It's more than a scrivener's error. She's
Can-
nowhere on the application.
Can she answer the question, please,
Let me-
for Mr. Scherer first?
Our attorney, please.
It's up to the board whether or not the board wants to allow Ms. Lukasik to intervene. Or you can say that because Mr. Hill filed the application and he's not here, that she's not able to intervene. Either way, it's up to the board. I will tell you that we generally allow interveners when they make a presence because by denying them access to the process, you are basically handing them an appellate remedy to go to court and say they were denied due process. So in the past, we haven't taken a hard line against interveners because it's just a matter of allowing them to be a part of the process.
So if I could, for clarification, Ms. Lukasik is a resident of Citrus County, correct?
If you want to inquire of Ms. Lukasik,
Miss-
where she lives,
could I
what
do
her
that?
interest is, you may.
Ms. Lukasik, are you a resident?
Mr. McAteer will yield the podium.
I'm sorry.
I'll yield the podium with a standing objection. If this is approved, we'll just carry that objection on the record. There's nothing in the record that says that she's ever applied.
You've been heard. Thank you, sir.
Good morning.
Good morning.
Take a deep breath. It's
Yeah,
okay.
I need to.
Okay. We're gonna work our way through some details. Number one, are you a resident of Citrus County?
Yes.
Okay. And you have an interest in this particular application?
Yes.
Are you a resident around the Betts Farm area?
My husband and I own a property that we live in at 5427 North Sierra Vista Drive off of North Citrus Avenue. We are less than 2 miles from the Betts Farm property on North Turkey Oak Road.
Okay, thank you. All my questions. So, based on the fact that we have a Citrus County resident that has a material interest in this particular application, and based on the precedent that in the past we have allowed interveners the opportunity to have representation and to present their case and then to participate with the applicant, and I stay with my motion that we should approve the intervener.
Is there any additional discussions regarding the motion?
Yeah,
Mr.
Mr. Chair.
Mr. Barm?
Go ahead, Madam
I would
Attorney.
only say, when you're done with this, we will make sure that Mr. McAteer knows that his objection is noted for the record.
I believe that would 100% be stated. Mr.
I
Barmes?
just want to say that I believe this Michael Hill is the same intervener that we welcomed during the data center process. He represented a couple hundred residents during that hearing. He lived in Gainesville then. We accepted him then. It's perfectly fine in my opinion, and from what I read from the intervener and all the documentations, I don't have a problem with it. I welcome the entire county to come in and speak. And if it's an intervener or a resident that doesn't have the speaking or the exact knowledge that she wants to represent, sure, I don't have a problem with bringing an out-of-town helper, intervener helper, per se.
Thank you, sir. Anyone else?
I concur with Mr. Barmetz.
All those in favor of the motion made first by Mr. Sheriff, seconded by myself for the intervener, Ms. Lukasik, represented by Mr. Hill. All those in favor?
Aye.
Opposed? Motion carries. Okay. Now on to Ms. Hoover, I believe.
No.
Sorry, sir. We did receive an email about the continuance. I know Mr. McAteer said previously that they are now withdrawing that. I just want to make sure the record is clear that they no longer want you to consider the continuance.
Do we need to vote on that?
I guess he's withdrawing his request.
Right, okay, so just making sure.
Just want to make a quick statement about that issue. There was a circuit court decision that came down. I think it's been well discussed in the community, the Pine Ridge case. That's the same underpinning process, the amendment of a DRI via the PUD process. The circuit court said that there's not a provision in the Citrus County Land Development Code that fits that process, therefore that approval was incorrect. We're now running on the same tracks that the court just cited as non-existent or incorrect. So we went back and forth. The client struggled with it, I struggled with it. We decided to just go forward, give the county a chance to address this between now and commission and see what's going to happen. I don't know how the county's going, it's not for me to say, it's for Ms. Linda to say how the county's going to brief the board and make a decision on how to address the results from that court decision. But it does put us in a funny spot because we're on the same foundation in this matter that Pine Ridge was in the other one. I don't represent Bravo Land Group in Pine Ridge. I'm not involved in that. I'm only involved in this case. It was brought in a few days ago due to a conflict. But there is a problem in that we have an underlying process, and we'll move forward today, recommending body. We want to hear what you have to say and what the residents have to say. But we have an underlying process that's been overturned by a circuit court. Who knows what a DCA will do, or whether you just write a new sentence in your code allowing for DRIs to be amended via the PUD process. But right now, we do have a troubling decision from a circuit court. So I have to bring that up. We decided, given all the work that's been done and everything on both sides, that we would agree just to move forward today, and then hopefully it gets addressed between now and the commission hearing.
Thank you, sir. I mean, we're not voting on anything, so I think we just needed to kind of clear the air and let it be known why the continuance was requested and therefore rescinded. We're all here. Mr. Barmez, you want to?
Mr. Chair. I have a lot of things. I've read the court order several times, researched our land development code multiple times during reading the court hearing. My personal opinion after reading it, the county and our residents are still on the hook for say, if we proceed with this application as it states. Our land development code was strictly read and put out for the world to read during the Hernando court. I believe the county and our residents deserve time for the process to continue with their, not necessarily continuance of this application, but their continuance of correcting, if there's any corrections need to be made in the land development code because of that hearing of Pine Ridge versus Citrus County. I would like to see that this application be withdrawn by the applicant until all the appeals, if any, because as of last night, there has been no appeals made to the circuit court in Hernando. If we continue this application under the same train rail as the attorney just spoke on, I don't think we can make a decision, nor we will be putting the Board of County Commissioners in the same cart as they were in with the courts in Hernando. And if the applicant does not like to, or would like to withdraw the application to continue today, the information that's in the packet today contains several substantive deficiencies that would prevent this commission from conducting a proper and legally decisive review. The key components of the application remain incomplete and inconsistent to our land development code, including the required studies and the staff requested revisions in the coordination with all the outside agencies. These aren't minor issues that need to be resolved. They can't be resolved if we deny the application today, we approve the application today, when it goes to the county commissioners to make a decision, they'll be in the same train track that we're on today. And I don't think it's fair for the county nor our residents to continue to fund something which could be possibly another lawsuit that the county and us taxpayers would have to pay if we continue this application and move forward today. So I would respectfully ask that the applicant deny or withdraw his application today until after the appeals and all the set forth of the Pine Ridge, because it's the exact same situation that we're in today with the DRI. And that's my stance on that. I knew the Madam Attorney was going to get me on this.
So I've listened to Mr. Barmez and I read the, I guess would be called the opinion from from the court?
Order.
The order? Okay, the order. It was
Circuit
labeled.
court.
Okay. So, based on what that document told me, the way I read it, was that the decision on the previous application that was made was an incorrect decision because there is no mechanism in the Land Development Code that allows a decision like that to be made on a DRI. Is that correct?
That's
nutshell?
some of what it said, yes. But bear in mind that decision or the order came out Friday. The Board of County Commissioners hasn't had an opportunity to meet with their lawyer, which I'm not representing them on that case. They haven't had a chance to meet with their lawyer to determine whether or not they're going to appeal that decision. So at this time, that decision is just sitting there waiting for the board to determine. They have 30 days to decide on whether or not to appeal it. So it really is not applicable to this board at this time because they may appeal it, and if they appeal it, it may be overturned and everything might be fine. The board might make other decisions. They may decide to amend the code and leave that order stand, but amend the code to fix any alleged errors in the code. I don't know what the board's going to do, but this was scheduled. There was no way we could get before the Board of County Commissioners before this meeting. So if y'all want to continue this meeting and this application until the board decides what it's going to do with that order, you can do that. If you don't want to continue it and you want to move forward, you can also move forward. And then, like Mr. McAteer said, it would be, there's a time lag between this meeting and when it would be considered by the board. The board might make a decision between now and then. So I understand everyone has made a big deal about that opinion, but right now, that's all it is a circuit court decision in that case. It does not have precedence over any other case that this county would undertake because it's a circuit court decision. It doesn't have precedential value. In other words, someone can't bring in that court case and say, this court says you're not allowed to do that because it only applies in the Pine Ridge case. It doesn't apply in any other cases.
Okay.
Although I understand many people don't understand that.
And Madam Chair,
Yeah.
question?
Mr. Chair.
Mr. Chair.
Mr. Chair, sorry. Madam Attorney.
So,
Mr.
and
Chair.
I didn't want to interrupt Ms. Lynn at all, or anyone else, but I'm
Please
under
don't interrupt.
direction by my client to move forward.
Mr. Chair, did
Hang
you
on,
have
hang on.
something?
Just finish, please finish.
The gentleman asked if we were going to withdraw.
Yes,
We're gonna withdraw.
that's what we want to know.
That's all.
You said no?
No.
Okay. Mr. Shara.
Okay. Just as a question, procedurally and timeline, there are some required dates. I guess I'm looking as much as Joanna as I am as Madam Attorney. If we elect to hear this case today and move forward and make a recommendation, does that set in place any timeline of which obligates the Board of County Commissioners to hear this case that potentially could create a further complication if the underlying issue isn't addressed and resolved by the Board of County Commissioners, the clock could time out?
Yeah, this is actually a 2024 application, so the clock is long past anything. It's not running.
So there's no time constraints per se that
There is
would limit
not.
our decision?
Right. We had tentatively set this for October 13th with the board. That's not carved in stone, but that is when we expected.
Mr. Chair,
Yeah, Mr. Barmez.
I just think in order to protect the integrity of our process and to ensure transparency to the public and avoid any procedural risk for both the county and the applicant, I am recommending that the Best Farm application, PUD 2733, be continued by the PDC until the discrepancies and we can get, address all the deficiencies and we can return with a complete and internal, consistent, and review-ready package that we do not have today. So for that reason, I'm asking the PDC to make a continuance on this application.
Mr. Chair.
Mr. Gilbert.
Wait, well, it's got to.
So is that a formal, like, are you making a formal motion?
That is a formal motion to continue this application, PUD 2733.
Applicant withdraws.
Yeah, so we've had this happen in the past, and the applicant actually was the one that had to apply for the continuance, in my experience. Is that not correct?
And you've also had it where this board did a continuance.
Okay. Mr. Gilbert.
Yeah, so.
Whoa. If there's a motion, you got to have a second before you have discussion.
Okay.
So if there's no
So
second.
we have a first for a continuance presented by Mr. Barmez.
I'd like to second.
Give me 1 second. Okay, so we have a motion for continuance with first by Mr. Barmez with the second by
We have Chuck Pigeon
Murphy.
with me, who's also the applicant's representative. I'm so sorry. This is not the way that I would want to present or.
I'm sorry, we're having a discussion at this moment.
Then we have to have a standing objection to this too. If there's a continuance, we object to it.
So do we have any discussions regarding the motion from the board?
Yes.
Yep.
Mr. Gilbert.
You go.
Sorry about that. So I'm not in favor of continuance, and here's why. Right now, we don't know if the BOCC is going to appeal, fight, change anything, right? Like, they could just say, they could say we agree with the opinion from the court, and we're going to change it and fix it up, or they might say, no, we were absolutely in the right. That's the BOCC's decision, not ours in my eyes, right? I'm not saying anyone up here is wrong. I think if we do a continuance, we're calling time out for a million reasons instead of just getting to the bottom of it, right? I personally would rather hear the case, make a recommendation, and if the BOCC decides to take their legal routes in different ways, I think that's up to them. I don't think we really have an input here on the opinion of Pine Ridge, like on what the county should do anyway. Like, we can't convince the BOCC to go one way or the other, like appeal or not. I personally would just say, hear it out, give our recommendation, and let the BOCC deal with the opinion. That's just my opinion.
Thank you, sir. Yes, sir.
I would agree. That's a good point you made. But I'm also a little confused. I like to think about things in a little simpler manner. When I have to admit, when I saw your request for the continuance, I was somewhat relieved to see that taking a step back was in your mind because of some of the words that you used in your letter: unpredictable legal posture, deficiency in the Citrus County Land Development Code, in the case you stated, the Pine Ridge versus Citrus County. Land Use Development Code does not contain the procedural mechanism necessary. These are your words, signed by you. Bravo. I thought that was a good idea based on your words. Now we're changing and you're back and you're saying we don't want to.
You're addressing
Okay,
the board,
I'm sorry, but I want him to hear
He hasn't
this.
been recognized.
Okay, excuse me, pardon me. But I do also believe that we need a clean process to proceed. So it's kind of a quandary, but I think that if we do allow this to continue and we vote on whatever's presented, then that goes to the Board of County Commissioners, and then that places the burden on them to clean up this perceived mess on the other one that they're referencing as part of their reason for asking for the continuance. So I would probably like to continue.
Mr. Sheriff.
I am not in support of continuing this. The PDC function is to evaluate any specific application, in the context of the Citrus County Comprehensive Plan and LDC. I do recognize that the uncertainties and potential costs that may occur based upon the ongoing legal activity with Pine Ridge. However, our role is to evaluate the application. Our role is to either recommend or approval or denial, and then allow the BOCC to do its work. So I would not support a continuance in this case.
Mr. Facemeyer?
I'm going to respectfully disagree with my colleague, Commissioner Barmes. Based on the advice of our counsel And she clearly indicated that while there's a legal dilemma with another case that is separate and apart from this case, maybe at some point they come together and they're resolved separately or collectively. I don't know. It's not our position to make a decision based on that. Mr. McAteer indicated that the applicant is withdrawing the request for continuance. Based on those two things, I will not support a vote to continue.
Thank you. Okay, so with all that said, Mr. Barmes?
I'd like just do a little small rebuttal on that. Maybe I didn't say it exactly correct. I believe we all received the order from the judge yesterday. We all, I'm sure, read it. In the order, it specifically states that we cannot, the way that our land development code is written, do a PUD through a DRI, through that process. That process is the same process that is presented in the package that I read that we're here for today. Why would we want not to continue? Why would we want to hear something that would put the county at jeopardy for another lawsuit? We need the time as the county, and the county residents, I'm sure, would appreciate that we might need to tweak a little small, one sentence will cover that order in our land development code. But we can't put it in there today, tomorrow, or next week. It could take a month or two, maybe 3. My request for the applicant to withdraw was to give them the time and the county the time to get our ducks in a row, for say. The continuance, since their refusal to withdraw, will lead us to the continuance, to give us the opportunity and give the applicant the opportunity to make everything right at the beginning. Why do we want to come back? I understand it's not our decision. It's going to go to the BOCC. And guess what? They're going to make that decision, whatever decision they make. But if it's not changed in the LDC, then we're in the same situation as we were at the Pine Ridge. I'm not trying to compare this application to the Pine Ridge, just the order that's in our packet that it specifically states that we cannot do that. So I was just asking for a continuance to get all that order. And I'm sure, and Madam Attorney or Ms. Joanne could tell us if one sentence could solve that issue in our land development code so we can move on with this process and every other application similar to this. That's all I'm saying.
The only thing I would say is that after reading what I read yesterday, I feel the same way you do. How can we make a vote on something that we're not really allowed to vote on if there's no mechanism that allows it? Based on what Ms. Lynn just said, that we shouldn't allow or can't allow that to set precedents for the decision made today. Only thing I can do in a situation, this is some high-level decisions that are being made. The only thing that I can do is rely on county attorney. I'm not an attorney. I'm just a volunteer. So I'm going to rely on what Ms. Lynn says. If Ms. Lynn says that she thinks that we can hear it and we can move forward and we don't allow that particular item to set precedence over this, then I'm going to say, okay, that's all I can go with. With that being said, as the chair, we have a divided board, so we're going to let the board decide. I'm not going to be the one that makes the decision. It's going to be the board decision. You have a motion that's on the table. It's been discussed, and we're going to vote on it. And if it votes in favor or denial, we're going to move forward with whichever way it goes. Okay? Does everyone respect that decision? That's the only way that we can make this proper in front of the room full of people here and in front of anybody else that's on YouTube and Chronicle and whoever else may want to discuss it, right? That's what a board is put here for. So with that said, is there any additional? Yes, sir.
Madam Attorney, could you clarify what the chairman just said in terms of a recommendation based on everything that you see to move forward or to ask for the continuance?
Well, I'm not making a recommendation on the continuance. That's in y'all's purview. But what I can tell you is that the Pine Ridge decision, that order that y'all got, Judge Cemento's order does not have precedential value on any other case in Citrus County. If it were a DCA opinion, a district court opinion, it would have precedential value, but it is merely a circuit court decision, so it doesn't have precedential value. So in other words, you don't have to follow that order. You're not by law required to follow that order. And we don't even know if that order is going to stand because it may be appealed.
So we don't know what we don't know yet.
No, and I suspect the applicant is going to appeal that decision, but
Yeah.
so even if the county doesn't appeal it, the applicant may appeal it. There's two parties to that appeal, the applicant and the county, and, well, of course, and the Pine Ridge folks. So there's actually three parties to that lawsuit, and we don't know, because it just happened, if anyone's going to appeal that.
Yeah, and it would be much better to hear it without a cloud hanging over it, whether it has precedent or not. There's still that uncertainty of the decision that was handed down Friday regarding the other project. So I might have to agree that a continuous could be more in order to allow this to be cleaned up so that we can do our job correctly, and this board does a very good job of vetting these things and making as good of a recommendation to the Board of County Commissioners as possible. That's a part of our charter, is to do that. And if we proceed with something under the cloud that we're under now, whether it has precedence or not, we could not possibly be really doing what the right thing is to do. So I'm gonna have to follow along with the recommendation.
Mr. Chair.
Do that.
Yes, Ms. Lenny.
I would say, hearing what you all are saying, even if the board and or the applicant in that case were to take an appeal, you're looking at a 8, 9, 10, 12-month process. So is it going to be the board's position that for 8 or 9 or 10 months or however long that takes, that this board isn't going to hear any applications to amend DRIs? Is staff going to be directed to not process DRI amendments? Because I know there's some others, and I believe there's probably some others in the pike.
That's a great question.
So it doesn't have precedential value. I don't know. I think you all need to consider that because there are other applications in the process.
Mr. Shara.
I'm going to try to work my way through this. It's about as clear as mud in my head. But in my mind, here's the reality. I don't think there's a cloud over our process to evaluate this specific application in lieu of or in the context of the comprehensive plan or the LDC. We haven't even gotten that far yet. My understanding from reading the court order, again, reading it several times, is there's a structural deficiency in the mechanism that would allow a DRI to be approved under the PUD process. That needs to be corrected at another level, by the BOCC. I believe we can do our job. I think that the applicant can present its case. We can understand the merits of the case or the deficiencies of the case and vote to make a recommendation or a denial based upon this application. So I just, for the purpose of discussion, I would reiterate that I don't think we should continue this.
Thank you, sir. Mr. Gilbert.
Last swing at this, I promise, boys and girls. So this is how I'm seeing it, right? If we hear the case today, right, let's say, I'm going to metaphorically go both ways, right? If we deny, right, based on the case, and send it, and the POCC decides to do any route they want, appeal, not appeal, whatever, we did our job by hearing that case. I am worried that if we continue, exactly what was said is going to happen. We're going to put this in pause for a couple more months, then we're going to get everybody back here again, and we're going to have the same exact discussion. And that's what I think. I would have loved to hear the BOCC have some kind of statement after that case, either, hey, we plan on fighting it, we plan on fixing it, we plan on adding a sentence, we plan on doing X. Unfortunately, they haven't yet, though. So that's why I just don't want us to be that block. I think we're just putting a temporary pause on a decision that we're going to have to make anyway. And I don't think it's going to change the mechanism or not. At our level, I think that's the BOCC's argument, and to be frank, their problem. Sorry.
I do agree with you on that, Commissioner Gilbert. My stance on that is if the court order is not significant to this case, then why was it in our package? Why are we looking at it? Why are we discussing it? Somewhere down the line, somebody said, this is part of this package. This is the same train track that we're on, perhaps. I think the county can fix this very quickly. And I think we can resolve it, but it's all up to the board. I'll go either way. I'll listen to it and make my decision based on the evidence and testimony presented to us, or would come back. I just
Mr.
don't
Chair.
want to.
Yes, Ms. Murphy.
Part of the reason that I'd like to see continuance is, as with the Pine Ridge meetings, we had an abundance of residents that came and spoke. And I think we would have overflow rooms if we would have had enough notice. And I think that we will be judged if we vote on this without the representation of the residents.
I believe that we've discussed this ad nauseum. Everybody's points have been heard and they're all valid. I'm just going to stand by my same point that says that Miss Lynn is the attorney on this particular panel that represents us. She's not representing the county. She's not representing the application. She's standing next to us. That's what I've learned in my years of being here. If Miss Lynn is going to say that she believes that we can hear this, then that's the only way that's going to be my guiding light. We're going to leave it up to the vote. It's been discussed. If there's no more further discussion, we're going to have the vote at this moment. So just to clarify, we have a motion by Mr. Barmez for a continuance of the application, and we have a second by Miss Murphy. All those in favor of the continuance, say aye.
Aye.
Can we have a count, please?
All right, Mr. Barmez,
Aye.
Mr. Bozeman,
Aye.
Mr. Shera,
Nay.
Mr. Facemeyer,
Aye.
Mr. Bramblett,
Nay.
Ms. Murphy,
Aye.
and Mr. Gilbert.
Nay.
All right, the nays have it. The motion does not pass.
Okay, 4-3. Does this move us along to Miss Hoover at this moment? Finally?
Finally. Yes. So this is PUD 2733, Pigeon 4 Bravo Land Group, LLC, Betts Farm. This application proposes to amend the Betts Farm development of regional impact. This application proposes to amend the Betts Farm development of regional impact. The existing DRI lies on North Turkey Oak Drive in Crystal River. This is the zoning map of the area. This is looking east on North Turkey Oak Drive with the site on the left of this photo. This is looking west on North Turkey Oak Drive. This is the existing DRI master plan. And the master plan submitted by the applicant. Thank you.
Thank you. The applicant, the podium is yours.
Thank you, Mr. Chair. Again, Daryl McAteer, McAteer Law PLC for Bravo Land Group. My address is 3314 Henderson Boulevard, Suite 100E in Tampa. I'm originally from Brooksville, so I spent about half my childhood in Citrus County, recreating and enjoying it. So I'm a little more familiar than the usual Tampa addresses are. That's not relevant to this hearing. I just want to give you a little bit of context. My intro is going to be very short before I introduce Chuck and ask to qualify him as an expert under the QJ rules. And that is, please remember, this is already entitled land. I know that, I've seen the correspondence. I know people don't like long-term DRIs, and it's a process from the 80s, but this was originally entitled in 88. There's been numerous amendments that Mr. Pigeon will go through. We're looking at an application that is the 2222 ordinance allowed for 1,542 units. This is a decrease to 1,466. And I would just like you to keep that in mind. This is different than a new PUD coming on raw land that's never been discussed. And I'm sure all of you know this. You've probably been hearing about Betts Farm half your lives. And I realize I'm the new one at the podium. But that doesn't make the application new. This has been going on for a long time. It's entitled property. And they have a way to move forward under multiple avenues. They wanted an improved avenue. With that, I'd like to bring up Mr. Pigeon, quickly ask him a few questions about his background so that I can ask you to qualify him as an expert, and he'll give his presentation, if that's all right with.
Yes, sir.
Okay, great. Good morning, Mr. Pigeon. Could you please state your full name and business address for the record?
Chuck Pigeon, 925 Southeast 17th Street, Ocala, Florida, professional engineer in the state of Florida, and an employee of Ardora Group, Inc.
Okay, and for how many years have you been a practicing engineer?
44 years, unfortunately.
Okay. And have you had significant experience with site plans, master site plans, and master site plan amendments?
Yes, sir. Incredible significance with probably over 100 projects in Citrus County.
If you could just ask your questions into the mic. We have people online other than just in the room. That way.
Okay, I didn't realize it wasn't picking me up.
Yeah, it was
You can use this
very light.
Okay, great.
And if you, Mr. Pigeon, if you would come to this microphone.
And did you have any involvement with the initial adoption of the Betts Farm DRI?
Yes, I was on staff as an engineer when the original DRI was activated.
Okay. With that, I would proffer Mr. Pigeon as an expert in his field and these matters, and ask the board for that recognition.
Yes.
Yes, sir.
All right. And I will get out of the way and let Mr. Pigeon do his jig.
Thank you very much. Once again, Chuck Pigeon. Appreciate your time and your vote. I do appreciate the vote. I think, just as a side note, I think it was good this board did not preempt a decision or make a decision that the county's in the wrong on their land development code, or that it's not correct. That is just an opinion, and everyone has an opinion, including the judges. So, therefore, I appreciate your vote on that. I do have to just make one statement before my full presentation. I'm a little bit concerned of what I heard one of the commissioners say, that they've already made a decision that things are deficient in the application. I've heard no testimony. I have heard no presentation by staff, or and in the ex parte discussion indicated there was zero communication with anyone, although he didn't visit the site. So I'm a little concerned that the decision has already been made that there's a deficiency. I think that's an opinion, and I think that the board needs to consider why that was said early on in the process.
Just remind Mr. Pigeon, you guys have 30 minutes, so
Yes, thank you. And I don't know if we need to be sworn in or not.
that's up to you. If you want everyone to be sworn, the applicant can make that.
If they're going to present expert testimony, I would like them to be sworn. But
Just the experts? You don't want everybody sworn?
everyone.
Are you?
Has
are
it
you,
has yeah?
Are you
I mean,
okay with that?
I feel like he wasn't just sworn in. Well, or
No, you accepted him as an expert witness, but he's
Okay.
asking to take the oath.
okay,
So if
sure, we would love that.
okay, so anybody who intends to testify today, if you would stand and take the oath, please. And then once you're sworn, when you come up to testify, if you would please let the board know that you've been sworn.
All right. Do you swear to tell the truth, the whole truth, and nothing but the truth?
I do.
All right.
I would say let the records show that they all said I do.
And Mr. Pigeon, some of the engineering staff is back there. I don't know if you saw them, but they took the oath also.
I don't worry about engineers.
They're experts, so.
Thank you, and I do have a short presentation. I try to keep this short. I thought this was a very straightforward process. and a very straightforward request. Back in 2024, we did meet with staff, had several meetings, and it was determined, and maybe not in the formal recommendation format, but it was asked to submit an amended master plan that was much more clarity and much more information than the current approved on-record master plan that we are to follow if we don't make an adjustment. So we agree that's good because it helps future reviews of applications, future reviews from staff, whether it be preliminary plats, record plats, improvement plans, signalization plans, anything. It helps if you have a better roadmap. So the process today was to establish a much better roadmap that was engineered as opposed to planned. And starting with the first slide, I'll just kind of get through the location part of it. So first slide, please. Or do I have this? Okay, well, that's that one. I'm not sure if it switches. As staff already pointed out, this is Betts Farm. General location for the public is that it is north of Crystal River, essentially just north of the Crystal River High School, which the Crystal River High School is part of Betts Farm, was the original construction of any vertical construction in Betts Farm, and is Betts Farm. This is just west of the Suncoast Parkway extension that you can see is under construction, east of County Road 495, Citrus Avenue, and bordered, for the west side and north side, bordered by Duke Power's transmission power line. Next slide. I'm not sure how this works. I'd like to just go a little bit of history. As the attorney had pointed out, this project was approved 100% in 1988. It includes 500 residential single-family homes, 500 condominiums, 500 cluster homes for a total of 1,500 units. So since 1988, this was allowed to go proceed and build this project. It went through a complete development regional impact process of reviews and approvals. And just so you understand that, there are 32 questions that must be answered to the state of Florida about development of the land. All 32 of those questions were answered. The book was very thick and was reviewed by every state agency, reviewed by the cities, reviewed by the county. There was negotiation, adjustments, and changes. And what was issued at the end of all that process in 1988 was a resolution, which we technically call the development order. That development order is about 40 pages long, and it addresses everything from air, water, sewer, roads, drainage, floodplains, vegetation, socioeconomic conditions, schools. Your planners can advise you or inform you as to what a DRI involves to get a DRI approval. In that same resolution, it included a significant amount of requirements for the developer to do in order to develop the property to mitigate all of the effects of 1,500 homes, whether it be transportation, water systems, sewer systems, air, setbacks, buffers, wildlife. And this development has done with previous owners, through the county's ownership, and then currently now under this, every condition of the development order was met to date. Some of those, just so you would know, involved, as an example, $125,000 was paid in 1988 for wildlife mitigation to help fund wildlife protection. That was given to the county. The county has used it somehow, spent it. It's great. Turkey Oak Drive is built specifically for Betts Farm, for the Betts Farm traffic. That road would not exist if it wasn't for Betts Farm. So the 1,500 trips or vehicles, homes, was there for Betts Farm. It is Betts Farm's road. It's dedicated to the county, and now the county is allowed to let citizens use it. It's great. For 39 years, citizens have been using Betts Farm Road. I love it. It's great, and it's good for the community. Water system. Betts Farm built the water system from the Meadowcrest Water Treatment Plant all the way to Betts Farm. The city of Crystal River got advantage of that and tied in their water system as an emergency backup water system. Betts Farm paid and built it as a mitigation requirement for the development. Sewer system. Betts Farm designed and built this backbone sewer system for Citrus County from Betts Farm all the way to the Meadowcrest Water Reclamation Facility. Pump station, pipes, gravity flows, everything. Everyone on State Road 44 has been using that sewer system, including the county using it, including the backup, since 1989, around that time frame. 39 years. It's a county system. That was the mitigation. Keeping in mind it was done through a developer's agreement with the county. So all that put together is the sewer system, the water system, the road systems, the drainage systems, all that was built for Betts Farm and their requirement. And I'm glad everybody gets to use it. I've used it probably 10,000 times to go to work back and forth. So just that little background, appreciate you listening to that. I want to just let you know that 11 times this DRI has been amended. It's been amended, including the county amending the DRI when they took their application through. So just a few things. There's been a residential open space and some notes we put on this slide. So basically, in 1990, there was no change to residential or open space, but it was amended because we, at that time, reached a formal agreement with the county on water systems and sewer systems, who pays, what's built, when it's turned over. So that was in 1990. And in 92, there was a phasing schedule that was adjusted, and then there was a bit of a change in the open space of 114 acres at the time. 2002, that resolution removed the traditional large detached single-family home sites and turned everything into clusters, because the thinking and technicality at that time was large residential home sites use a lot of grass, use a lot of fertilizer, use a lot of pesticides, take down more trees for a single resident. The plan is cluster everything together as much as you can and make everything tight, make little neighborhoods. People love those neighborhoods. They love the block parties, but save the environment, save the wetlands. So that's exactly why they removed the detached large single-family homes and said, make this entire development cluster. At that time, it went to 1,014 cluster units, and we can explain what that is, and 528 condo units. And in this case, the word and use of condominium, and it's written in the development order, really means multifamily. But you use the word condominium because in the world of traffic engineering, condominiums produce less traffic than a single-family home. Cluster units produce less traffic than a single-family large home. So that's why they use the terminology condominiums. The state transportation engineers understood that. So when we say condo, that's a platting process of how you plat land to sell in a real estate transaction and recording transaction. So it's really multifamily. 2003, there was no change, but the drainage retention area on North Turkey Oak Drive was deeded to the county. And they wanted another retention pond for the improvements that they were doing related to the school in that area. And then 2006, there was no changes to residential or open space, but it was a transfer of some vehicle trips that were done, where Betts Farm had a lot of vehicle trips, and they spent a lot of money on roads and everything. So they transferred some of those to another project. And then 2007, no change. 2011, no change. 2019 was one of the biggest changes. And in 2019, the school wanted to expand. So in that expansion, take back. In 2019, there was a big one, but it was an interchange where you can interchange clusters and multifamily. You can kind of switch back and forth depending on what the market predicted. 2022, which was right after the 19 decision, was the bigger one where it went in to remove from the master plan the school site. And the school purchased everything south of Turkey Oak Drive to expand their school. The school, in my opinion, is still in the DRI. It's never left the DRI. We can ask Mr. Dixon, his opinion, but it's not in the master plan. They already have their plan. They've got their site plan approval as part of DRI. So that was the big one in 2022, and the number of units were increased to 1,542. They were increased basically because the traffic of a cluster home is less than the traffic of a detached single-family home, so they were able to get a few more units, and it met the 5% criteria for increase without substantial. It doesn't matter at this point, but we are approved currently today for 1,542 units on the property of 527 acres, less the school, which puts it at around 327 acres. At that time, with the removal of Track B, there was a lot of open space that was removed all around the school, but what remained was 86 acres of open space. And then lastly, we're here today, 2026. And in this application, we are requesting a reduction in the number of units based on sound engineering of looking what is reasonable, what is unique, and what fits on that property to work in the environment and protect the surrounding area and be compatible with the adjacent properties, utilize the infrastructure that's been built for Betts Farm, but not overemphasize and overuse it. So we're reducing the lot count and the unit count from the 1,542 down to 1,466 units. We are also looking to increase the open space from 86 acres to 89 acres. We're able to do that by re-engineering some things. And then also, we're looking to, and keep in mind, that also includes the 70 acres that was removed from the, what you call the purchased parcel, which would be developed. That 70-foot strip all along Turkey Oak Drive was retained by the county for possibly some future road expansion. So in that calculation, it becomes roadway as opposed to open space. 70 feet all along Turkey Oak Drive. So when you think about that, how did we increase the open space, but yet we lost 70 feet all along Turkey Oak that was open space? We were able to do that. We wanted to conform to the DRI requirements, and the purpose was to create a map and a plan that was engineered that met code and that also was a better roadmap to move forward so staff would not get confused when documents are turned in for approval for construction. There was a lot to say, more than I wanted to, but I think it was important that you understand the background and some history as to why we're here today. Next slide, please. Staff pointed out, this is the current plan. This is as detailed as it gets. This is the current master plan. We can go out there and build this today after, getting improvement plans and the normal process of construction documents. If you notice on there, one big issue, there's one entrance into this project. It's at the traffic signal at the high school. Horrible. Never recommended by engineering. We needed to fix that. According to this DRI, we can't. We've got to comply and follow the master plan. Next slide, please. Much better engineered plan was to meet the code and also to meet good sound engineering. We have two entrances. Anything greater, your code says anything larger than 75 lots must have two collector roadways, two access adjacent to a collector road. This accomplishes that. It reduces the internal road, master road length, which then reduces the impacts and makes for more efficient operations of traffic. It puts the intersections where they need to be there safe. It gets an intersection away from the school so that it doesn't impact the school traffic signal. It's just sound engineering. Next slide, please. So this is the concept plan. What you saw previously is the official master plan, Map H. This is the concept plan that is part of the record, which essentially an exhibit to the master plan. This helps understand how we envision the project to lay out, how we're protecting wetlands, how we're dealing with stormwater and water quality treatment before anything touches the wetlands, where we're putting the multifamily area and the more intense area with its own entrance area away from the school. Just a lot of really good things in here. Next slide, please. This is just a brief comparison, just to help you understand the difference. And the difference of unit types in the DRI, and just a matter of record, every document since 1988, including the resolutions, development order, the 32 questions, every application since then, that's all part of the Betts Farm record. We don't need to reduplicate that same information and do not need to copy 10,000 pages of documents and resubmit them to the county for this application. This is an amendment to what's already been submitted. That's what we're dealing with today. Already did the environmental reports, geotechnical reports, traffic reports, water sewer analysis, on and on and on. So with this map, starting at the top, the cluster units, which is all that's allowed in this project, cluster units and condominiums, if they were single-family detached, the traditional single-family in the original DRI was 7,200 square feet minimum lot size. A cluster unit in the original DRI, which is a single-family, could be detached or could be attached, was 3,200 square feet. There were no minimum lot width requirements for the single-family. And currently, and you may know this, in your code, there is no minimum lot width for a single-family home in Citrus County in your code. Just like you can have a zero-line lot line home, single-family, built today, zero lot line, provided you get a 5-foot easement from the adjacent property owner. This application, and why we're doing this process, to clarify and set some specifics in your PUD application process. It says you need to set standards for what you want to develop. So we're setting the standards. We said the standard would be 4,800 square feet and a minimum lot size 40 feet wide. That's the standard. It exceeds the code by 40 feet. So that's the standard. The next unit is cluster units that are attached. They could be patio homes, duplexes, triplexes, quadplexes. Those are attached to cluster homes. And keep in mind, the cluster home is really to group everything together in a tight format and save the rest of the environment as much as you can. That's encouraged, that's unique, and that's the emphasis of a PUD, why we have the flexibility. So attached, 3,200 minimum is the existing DRI today, 20-foot wide, 20-foot wide units. What we're proposing is the same 3,200 square feet, but we would go with 35-foot wide, because we know realistically in the world of real estate and marketing, 35-foot wide, an attached unit is a proper width. It's based on market, it's based on real estate, and it's based on what we're seeing throughout the county. The condo units, as I mentioned, are multifamily, 8 to 10 units per acre is what's allowed. There was no minimum lot size in the current approved PUD master plan. We're proposing a minimum 2,000 square feet and a minimum 20-foot wide. Therefore, it fits a garage and it fits a driveway, and it's traditional as to how you deal with multifamily, that everyone has at least 20 feet touching the road. You're not stuck up somewhere with no frontage. Wetland impacts, just to let you know, currently today the DRI allows 10% of that wetland to be bulldozed. That's what the county said we could do. That's what the county agreed to. That's what's in the development order, and that's what's in the resolution. That equals 6.85 acres. What we are proposing with this master plan that's been engineered is less than 0.5% of the wetlands being impacted, 0.37 acres, and it's one little tiny isolated wetland that is in the middle. And it could be considered almost ephemeral because of the destruction that has taken place of those wetlands out there after the county owned the property. It was public property, ATVs and four-wheelers and everything else is out there. They were destroying the wetlands. It was a mud hole. It's gotten a lot nicer in the last 2 years that has been stopped because of this process. But anyway, that particular wetland we could not save. Impervious surface, right now the code allows 50% impervious over the entire project area. We are not proposing to change that at all. Our plan is, when we analyze it and look at it, it's closer to about 46%. So we feel confident with this plan layout that we're going to meet that 50% impervious overall for the development. Even though we're clustering things much closer together, and in the neighborhoods themselves, it would be in the range of about 70% because you have driveways and houses and sidewalks and all that stuff. But outside of that, overall, we're less than 50%. Setbacks, we set some criteria for setbacks. Existing DRI allows building setbacks of 20 feet from the front, 0 from the side, and 5 feet from the rear lot line. We're proposing the same 20 feet from the front. If you have a second frontage, which is a side street, it would be 10 feet off the side street. And still the 0 lot line for attached housing only is what we would propose. And we are proposing that because we would have a rear setback of 10 feet. And then for the condominiums, it would be 5 feet, because condominiums, if you define them, sometimes you get 5 feet off the back of your house, but your property line becomes more of a demarcation of the condominium association that would maintain what part of their site is maintained. So condominiums, you tend to have a closer backyard. And then staff put in there and recommended 0 setback for pool enclosures. Doesn't really matter to us, but I think there's been issues that they've seen over time in the county where pool enclosure gets a little bit close to the property line. So they said just put 0 in for pool enclosures. I'm not even sure if we're going to have pool enclosures. And then the maximum building height, the same, 35 feet. It was 45 feet for condos, but we're proposing 35 feet. Next slide, please. So just to kind of summarize, and I meant it was going to be short, but I think it's important to get this information out there. Summarize, Betts Farms approved development regional impact. The development order was issued in March 1, 1998. The resolution included 48 conditions and 11 general requirements. It was not a short document. Betts Farms had 11 amendments over the years, and developer obligations of the DRI have been met 100% to date. The DRI required infrastructure, and it's been constructed. Mentioned roads, utilities, so on and so forth. And that's been to the benefit of the county for like 37 years. Infrastructure improvements and contributions have been made, including that $125,000 I mentioned to the Wildlife Fund. This proposed master plan amendment reduces the total number of units and subsequently reduces the regional impact. And had we done this back in 1988, we would have had less road, less to do, less to pay for. But time goes on. The PUD approved in 2019, which is the current approved PUD, has only 9 conditions. This PUD, after staff review, coordination, determining this application was sufficient for review, we now have 20 conditions, but there's about 30 parts to it. So we've significantly added information to this process. I believe staff's going to present or may present and address the conditions themselves. So I won't go into condition by condition. I was going to end there, but I need to, in addition to this presentation, I need to touch on a few points because of the decision about the intervener. Just get a specific few points. So with that, in the intervener's memorandum document that was submitted, there was a comment about flexibility and uniqueness. I'd like to point out and read some of this so you get the clear understanding. Betts Farms already an approved PUD. It's been determined a PUD a long time ago. It's been through many processes. So we don't need to prove that this is a PUD or that we even meet a PUD criteria. It is a PUD today. With that understanding, in section 4300 of the Land Development Code, the purpose of the PUD in terms of the, quote, flexibility and uniqueness, the word flexibility is included so that the county is flexible, not the project, not the engineer, not the developer, it says it must be unique and flexible. The county needs to be flexible when it comes to a PUD so that you can do creative and imaginative things. So it's the county that has to be flexible, and specifically so that we can have uniqueness. So it's not that the development design must be flexible. This is done so that the design can be creative and imaginative, and we have produced exactly that with this new version of the map and the roadmap to go by.
Mr. Pigeon, you're going to need to wrap it up real quick.
Yes, sir. The next item would just be the flood. There was a discussion about flooding and functions. So the comprehensive plan objective 3.2 says this objective considers that the 100-year floodplain encroachments. That's what the objective is. Don't impact the floodplain. Based on the presentation and the plan layout and the associated drainage system design that went along with that, that was presented, reviewed, and approved by the Water Management District. This project has a construction permit approval from the Water Management District to build this project. They have reviewed all the floodplains, they've reviewed all the conveyance systems, they have reviewed that and issued a construction permit as of March of 2026.
Thank you, Mr. Pigeon.
Thank you. And last slide, please.
I'm sorry, your time is up.
Okay, I was just the last slide. Just recommend that you approve this amendment. Thank you, sir.
Thank you, sir. I appreciate your time. Just a point of order, we're still typical process from this point forward, correct? Board questions?
Yes, if anyone has any cross-examination of the witness, either the intervener or staff.
Okay. Do you have any cross-examination?
No, Mr. Chair, I have no cross-examination.
Thank you, sir. Staff?
Yes, please.
Yes.
Sorry, Mr. Pigeon. We've had a lot of time to go back and forth on this application, and a lot of items have been resolved, I think, but a couple questions for you. Open space, I had calculated 84.8 acres, and one of your slides says 89.2, and I know you talked about how you were able to re-engineer. So are you willing to commit to 89.2 on the application? It's not in the conditions of approval at this time.
Okay, a very good question. I appreciate that. The early submittals of the application had approximately 84 acres of open space, and it had about 31 acres of roadway. And after reviewing and looking at it and saying, well, wait a minute, we were supposed to have 86. We started out with more than 86, and then why did this map end up to be 84? Well, we went back and looked, and what happened is the property that the county reserved and held as future road expansions and future drainage, all of the drainage retention areas that went with that roadway were classified in this calculation as road. It's never been done like that before. It's not part of the required and the definition of open space in the DRI. So we took out approximately like 3 acres, maybe 4 acres of drainage retention areas that should have been classified as open space, not road. And we made that correction and furnished that correction to the director.
So yeah, let's clarify that a little bit. Your slide said that open space does not include wetlands or wet ponds. The master plan says it does include wetlands, natural wetland areas, and the proposed condition is it also includes drainage retention areas. So are you proposing in your PUD that open space includes wetlands, wet ponds, and drainage retention areas?
That's two parts of that to answer that question. So in the DRI, there's specifically defined what open space is. Since 1988 up until today, everything has been defined to include all drainage retention areas, all buffers, all wetlands are considered open space. That's in the resolution, it's in the development order, it's in the DRI. So when we say that there's 86 acres, I may have to look back and make sure that includes buffers, and that includes drainage retention areas, and that includes does not include the wetlands. Right. I want to just make sure you understand. If we add the wetlands, we got to add another 68 plus something acres to the open space. So we didn't want to confuse anybody and say, We have open space, and then we have wetlands. We're not gonna combine the two together and try to fool somebody. Wetlands are wetlands, open space, so the clarification is we could have added it in and said it was open space. But the way the original DRI was presented, so that you weren't confused between the existing plan and the proposed plan, because the existing plan had a separate calculation that they put in for open space, they didn't include wetlands. So we said, okay, we'll keep it the same, because we're gonna keep it the same.
Okay, so we'd modify the master plan general note to say it does not include designated wetland areas. You are including open drainage areas and open areas around land use, which you say, but not the wetland areas.
Not the wetlands.
Okay.
Yes, ma'am.
All right, and let's talk about most of the conditions I think we're somewhat in agreement with, but one of them, and I have some representatives from Public Works when I do my presentation, but we're talking about the turn lane improvements. So I know, and I am on condition 2, access management number, bullet F. If turn lane improvements are warranted in the Turkey Oak right-of-way dedication will be required, and you'd like to add as needed. Can you address that a little bit, please?
Well, yes, all we ask is that the county respect the language that's in their comprehensive plan, and that we use exactly the same language that's in the comp plan when it comes to dedication of future right-of-way. I could take time and get the exact word, but essentially what it says is if you add a turn lane, add right-of-way. This is a unique case because road that's out there is Betts Farm DRI Road. It was designed and built specifically to handle Betts Farm, whether it needed a turn lane or didn't need a turn lane, whether it had 2 lanes, whether it had 4 lanes, that is Betts Farm's road. The county wanted to say, if we add another turn lane, you must add more right-of-way. And we said that's not what the code said. The code says if it's warranted. So please just put in the condition that if we add a turn lane, if it's warranted, we will. Keeping in mind the county reserved another 70 feet of right-of-way that is not being used right now. You can put an awful lot in an 80-foot right-of-way plus a 70-foot right-of-way. You can put a lot of road in there. So for us to add a lane and then go past the 70 feet of trees and add another 12 feet, we got to determine if it's warranted. I think we'll work with the county engineer in the future to determine if it's warranted. That's why we asked for the language change, to just follow the code.
I wanted you to give it a chance to address that. We'll talk about that in our presentation. I think bullet G about the retained right-of-way referenced is for future widening. You had proposed that for removal, but I think that's no longer correct. You don't care about that particular comment.
Which comment, please?
I'm on G. The retained right-of-way referenced in the application is for future widening.
Well, some of this, and in all respect to the staff and all the work that they do, it's a tremendously difficult job. It takes a lot of conditions are written as conditions. Remember, we have 40-something conditions already in the development order. We've got 9 conditions already approved today. We're going to add more stuff. This particular comment, which I can't if it stays or not, it just says the retained right-of-way referenced in the application is for future widening. Has nothing to do with the developer. It doesn't have anything to do with a condition that we must do. It's just a statement. The future right-of-way may be used for a road. Every right-of-way in Citrus County could be used for a road. It's just, it isn't necessary. So we said, hey, maybe just want to remove it. Really doesn't matter to us.
All right. The single-family detached minimum lot width, we've had some discussions on that. You're proposing 40 feet. Staff is suggesting 50. Can you address that, please?
Yes, we've asked for 40 foot. If you remember in the presentation, right now it's 0 for single-family homes detached in the code. We're allowed. If it's cluster homes, it's 20. So we could say, okay, we'll do nothing. We'll just put in what we want because that's what the DRI allows. Well, we wanted to nail it down and say we prefer to say 40 feet so everybody understands it's not going to get tinier, it's not going to get bigger. And we did that so that if we have a 5-foot side yard setback as opposed to 0, then it makes sense that someone say, well, this is a detached single-family home. Well, it's still a cluster home, whether it's attached or detached. Cluster homes are allowed 0 lot line homes. We're saying, well, does everybody want to have a 0 lot line home and a 5-foot easement on their neighbor's yard? Why don't we just do this properly? move the house over 5 feet, tell them they have to have a 5-foot setback, and tell them they have to have a minimum 40 feet. That's all we're asking for. In today's market, you need a combination of units, 40s, 50s, 60s, 70s. Buyers have different preferences. 40 feet reduces the lawn, reduces the landscaping, reduces the maintenance, reduces everything, and being in and around Crystal River, the goal is smaller lawns, less fertilizer, less everything. So that was our 40-foot wide. We asked the board to understand that not all the homes are going to be 40. It's just the smallest one we could have.
I swear I'm almost done, Mr. Chair. I heard you say that staff told you to do a 0-foot setback for pool enclosures. That is absolutely incorrect. It doesn't sound like you're actually supporting that either. Can we remove that proposed condition of a 0-foot setback for pool enclosures? That's not something this board usually is very favorable about.
I'm not sure where it came from in terms of, we submitted as the applicant, submitted a recommended conditions after we got staff's report. When they came back to us, in there was 0 setback rear lot line.
Do you want to remove it? I'm not trying to blame.
We can remove it.
Okay, thank you.
That's fine.
So that's proposed in condition 15. And then the last one is the sidewalks. I think we've actually finally addressed that. You do say that sidewalks will be on internal roadways. We're saying a minimum 4 foot wide, and also that they have to have a pedestrian connection to the sidewalks on North Turkey Oak. You had instead proposed meet the criteria of the LDC. That's not very specific. Are you okay with the 4 foot internal roadways on both sides and the connection to Turkey Oak?
Well, we had just recommended that we basically reiterate the code. It says a minimum 4 foot wide sidewalks must meet the criteria of the Land Development Code.
There's not a criteria to connect to Turkey Oak, and there's a sidewalk there, so we would want that to be supported. That's why I'm trying to see if that condition can be amended in that way.
Right, and here we are, just so you understand. The current approved PUD plan says we must put sidewalks on collector roadways and on Turkey Oak. Sidewalks are already on Turkey Oak, but that's what it says. What we are proposing is a minimum 4 foot wide sidewalk must meet the criteria of the Land Development Code. The DRI already tells us where it's supposed to be. So what this says is provide on each side of the internal roadways. So basically it's saying, regardless of what the DRI says, you do not have to have sidewalks in the current DRI. Now we're saying you have to have sidewalks. Now our client does want to build sidewalks. They want them for safety and for the community, and we're intending on sidewalks. But we felt, is it appropriate that they're required to be put in now? Either way, we're okay with it, but we asked to just met the code. Just say we're going to meet the code.
He's answered my questions. Thank you, Chair.
Questions from the board?
He said no. He said he had.
Yep, I already asked him. Yeah, Mr. Barmes.
I don't have anything at this time I want to add.
Oh, okay. Mr. Facemeyer?
Mr. Pigeon, you mentioned earlier that Turkey Oak and was basically a Betts Farm Road and the associated infrastructure. You know, you kind of implied that, that's why it's there.
Yes, sir.
Can you fill me in? Was that, do you think that was just part of the normal county process? Was it built with impact fees? Was it built with a donation from previous owner? Help me understand that.
Okay, I don't remember exactly all the agreement process back then. I do know that the roadway was built, and I'm not sure if it was 100% paid for by the developer, but substantially paid for by the developer. I believe there were some impact fee credits because of the oversizing or the additional length. This project also included realignment and improvements to North Holiday Drive to make it a much safer road. If you remember, maybe you do or don't, it was a pretty low level country road before. So it was improved Turkey Oak, build Turkey Oak all the way from 495, which didn't exist, all the way to North Holiday Drive, and improved North Holiday Drive to an 80-foot right-of-way and a high, arterial road. substantially built and paid for by the developer, but I think there was some impact fee credits because of the over design. Water, 100% paid for. Sewer, 100% paid for by the developer and dedicated to the county. Essentially back then was whatever your development needs, you build, you pay for, and you take care of. It was the roadmap for the future of development, and Citrus County was right on top of how to do that. They understood how to do that, and as consultants for the county back then, we made sure the developer paid his fair share. We didn't know it was going to take 37 years to get here today, but that's where we were back then.
Thank you.
Mr. Bozeman.
And Chuck, is that now known as concurrency?
Back then, concurrency didn't exist, and
But in that form, it kind of did.
form, it was a development order under statute, Florida
and-
Statute 380.
Yep.
And it was a developer's, development order resolution.
Gotcha. That answered one of the questions I have. I be honest, I still stand by my vote earlier, but I'm glad we did proceed because it's given us an opportunity to see what's going to be moved forward. I was concerned about the impact on the public input when they got the letter that we're going to withdraw and ask for a continuance. Maybe the room would have been twice as full. I don't know. It's hard to say. But I do, some of the things that I noticed in the improvements on the proposal, slightly increased the ISR, or reduced impervious.
Yes, sir.
Okay. The additional entrance road, is now part of that's done. That's a done deal, right?
Only
If
if you
it's done.
approve this plan will we have two entrances instead of one.
Right. You could proceed with one
Yes, sir.
coming to the school, so that's good.
And then debate with staff how we meet code.
Okay.
We can call quandary. You have an approved plan that the county currently has with one entrance.
Okay. All right. I'll come back in a little while.
Mr. Shara.
Morning, Chuck.
Yes, sir.
I'm gonna try to walk through this quickly, but there's a lot to unpack here. Let me just start out to be sure I understand the big picture. The big picture beginning in 1988, does the current owner own that property now?
The county, Citrus County, Florida, owns the property. Bravo Land Group has a purchase contract to purchase 148 acres of the county's ownership and develop it, move forward with the DRI, what the DRI allows in terms of the entitlements. They have not purchased it yet.
So 148 acres is open to purchase?
Excuse me, 348 acres, sir.
Got it, okay, fair enough. And it's my understanding then that the DRI in its current form passes with title. So the rights and privileges of that DRI will accrue to you or the applicant when the title changes?
Yes, sir.
Okay. Your knowledge, are these DRI documents, have they been maintained over time and they up to date? And you've talked about aged documents, and we know that the time has moved on, your reference, and there's more stringent environmental conditions in some cases. There's more stringent in almost any area of whether it's more well-defined conditions. Does the DRI address those, and is it, in your understanding, is it required to meet the current standards?
Well, yes and no. I believe your growth manager staff can tell you how they maintain the records, but yes, I believe all the records are on file with the county in the planning department purview.
I guess where I'm going to, there won't be a debate between a applicant and the county saying, well, the DRI in 1988 allowed us to do this, but we're now in 2026, 2027, so we're not going to comply with the current environmental, lighting, noise, whatever the condition may be, standard, because we're deferring to 1988.
And that's the whole purpose of this cleanup today, because a lot of rules, regulations, the land development code's been amended several times. The comp plan's been amended several times. State law has come in. The Water Management District, SWIFMA, has changed, DOT. So this is helping get to the current code. In fact, just as a side note, the current development order says we must comply with the Public Works Manual 8301. 8301 says we are to design the drainage for a 25-year storm. That's the criteria. Well, now we're a 100-year storm, flood levels, everything. The criteria's changed substantially. So do we want to go with what the development order says to design by, or do we want to go with today? So we take the route of today, comply as much as practical as possible, and I think are doing that. So
I'm going to follow up
codes
with
change
the county on those same kind of issues.
Right.
So what is a benefit to the county and to the citizens of the county of your proposed variances and changes?
Well, the benefit is we have a much clearer, exact picture of what's proposed to be built. What wetlands are proposed to be protected, what areas are to be buffered, and the sizes of those buffers. And just as an example, we've got 50-foot buffers around the entire project, required by the DRI, maintained by this project. We have defined in much greater detail what that buffer means. Right now, the DRI says natural buffer, which means I don't touch anything, just leave it. Well, we've changed that to say you've got to have vegetation, if the trees don't exist, you got to put trees in. So we've defined better what that buffer is, and that's with the help of working with staff to define that. On just other issues of, like the sidewalks. We're proposing sidewalks, our master plan discusses it, and we put that in. With regard to Florida-friendly landscaping and Florida yards and neighborhoods, the DRI does not say we have to do that. Every condition up to today does not say we need to comply with that. And what we've done is put that in this plan and written condition number 8 on the master plan that we will comply with Florida yards and neighborhood. We will comply with that and follow that because it's encouraged. It's not required by your land development code. It's encouraged by your code. So that's the kind of cleanup we're talking about. And to make sure that we were clear and clean, and we've already received the Water Management District permit for construction. So they have reviewed every drainage retention area, every fill, every cut, every location, the flow. So we said it's not a guess anymore about how we're managing stormwater or what the impact is.
They have reviewed those.
Reviewed everyone, including water quality.
In what time frame?
They reviewed that and issued the permit March of this year, just a few months ago.
Okay, so the permits, in fact, are not aged. Those permits are current.
Those are current.
Regulations are current.
Current permits, including a current permit from the Army Corps of Engineers.
Okay.
So those.
Good. And let me just build on what you just said. You want clarity in fact what you're going to build. And remember the perspective. We all bring history, and we bring the history of sitting in this table and thinking about other applications that have had DRIs with them, and there's been a lack of clarity in some particular case that we've just beat the drum on. So is there a development agreement in place or a drafted development agreement in place that's being between you and the county?
There's a resolution, and then there are the series of 11 approvals with conditions. So it's not, quote, a developer's agreement. But say there was a developer's agreement for the wall of water and sewer, that's been satisfied. There was a developer's agreement for traffic and transportation, that's been satisfied. So there were several developer agreements in the process of getting here today that were taken care of years ago. There's no current, to my knowledge, in place an active developer's agreement that requires a developer to do something. It has conditions and approvals, but all the obligations have been met. So So when you talk about a developer's agreement, I'm not quite sure whether you mean an agreement to build something or an agreement to not do something.
This is unique because it is as old as it is, and as we unpack this, we'll get into maybe some more of that. So you said you want clarity on what you're going to build and where. So I was looking in the packet, and it's page 111, if you could, of our overall page numbering system, not your presentation, but the overall. Could we call that up?
I don't believe we have that. We don't have it on a slide, no.
We'll have it on slide. Okay, can you go back to your slide, please? That I guess your slide was it's called PUD Concept Plan Exhibit A.
Yes, if you go to the very last slide in the presentation, or very, very, very last slide. Right there. That is the official Exhibit A that is on file.
This is an Exhibit A to the master plan. So as we look at this, and let's just walk through this to understand what it is you're building. Understand the two entrances, the single-family attached and detached, and which we're going to probably talk about more because of lot width. Describe single-family attached and detached, and where is it shown? What is shown on this?
Okay, so the kind of the pinkish color, that is the cluster homes. And those would be the more traditional detached home, or it could be duplexes or triplexes or zero. The current market thinking is that the stuff in pink would be detached homes. That's what most folks like. That's what most folks want. So we think that most of that pink area would be detached cluster housing. The area in yellow, kind of the yellowish color, that would be the interior inside the loop road would be attached multifamily townhomes. It'd be 20, 24, 28, 20, 30-foot wide, but townhomes grouped in like groups of 4 or 6. This stuff on the eastern property boundary in yellow, those would be traditional duplex homes. Call them patio homes, villa homes. It would just be 2 units together. It would look like a bigger single-family house, but really it's 2 units clustered together. So that's on the eastern side. Those are the 3 different products that we're showing.
Interchangeability.
Changeability.
Interchangeability. Does that, are you proposing that those multifamily homes or townhomes could be relocated to any other area on this site?
There is interchangeability in the code and currently allowed, the interchangeability. That was the 2019. So it really is driven by the market. If we find that, hey, the townhomes are a very affordable product in the West Citrus County area, we may elect to say, well, let's not do that little loop in the middle as detached or patio homes, but let's do that. We do have interchangeability, but we're limited to no more than 1,400.
Are you willing to commit as a condition that your multifamily homes and townhomes would be relegated to the areas you've identified on this drawing, adjacent to Turkey Oak and on the internal road?
Well, let me just answer that question. I can't relegate because we don't know what the future is. We are asking for 20 years to build it all out, to give everybody time to do what they need to do, and hopefully use local builders and local people.
Chuck, as a matter of just not to cut you off, but I realize that. I'm sorry, but the folks, we think about compatibility, and the folks who live around this area, I think they have a reasonable expectation to understand what is being built and what they're going to look at.
Right.
And that if you have a rural area, if you have a home on a piece of land, that you're not going to look at the back end of a condo or a townhouse. And we went through a similar kind of conversation in a previous project. It's major that people remember, and one of the conditions that we were strong about is that people should have that expectation for putting their life savings into a home and a piece of property. Are you willing to accept a condition that the townhomes or these multifamily homes be located where you're showing them here?
The answer is yes, because if we want to move them, we need to come back with a new plan and get the new plan approved. So this is the plan, and if I wanted to move multifamily, let's say all the way to the west side and put it over by a wetland somewhere, we still have to bring that plan back for approval. Now, depending on what the change is, it could be an administrative approval by the growth management director or this board. But we have to bring a plan back for approval.
So would you be willing to put a condition into the staff, or make it a staff condition, that the townhomes and multifamily homes be located in the area you've identified here in Exhibit A? I think I heard you say yes, but then you also elaborated, and I'm not sure what you said.
Well, yeah, I didn't want you to know that we say yes, and then you realize, well, we say yes to this plan, but we can go amend the plan. What I want to make sure is that we have duplexes right now shown on the eastern property boundary. Those could become detached single-family clusters. What you're saying is, let's make sure we don't have condominiums along that eastern property boundary. I can agree to that.
Well, can you agree that your single-family homes as shown in purple would not become condominiums or multi-story units?
I
Again,
don't have that obligation to say that.
Adjacent to this.
All I have is obligation to say that we had less than 1,400 homes. That's all I can answer to. I mean, this is the plan we're presenting. This is the plan that'll be approved or requesting to be approved. If we want to change the plan, like I said, I got to come back and show you a new plan.
If you would, I'm going to stand back. I got a few more questions. I don't want to dominate the conversation.
Anyone else? Mr. Gilbert.
I just have one. I've heard you say a lot today, we can do this today. How come we haven't?
It was more a case of dealing with staff and talking with that. They said, can we submit a new plan that everyone can understand what you want to build and where the roads are, and get a proper PUD master plan on file? Because the one that's on file is a bubble diagram, and it just says, here's cluster everywhere. And we say, well, that isn't as clear an understanding. Plus, the current plan has one access, and we needed to show two. So that's why we're doing this process.
Okay, thank you.
Anyone else?
Yeah, Mr. Chair.
Mr. Barmez.
Mr. Pigeon, what's the definition of a concept plan?
I don't believe I have that in front of me. It's in your code.
What's your opinion of a conceptual plan?
Well, I don't know that I should give my opinion. As an expert, the concept is exactly what you see. It doesn't have defined geometry. It doesn't have the definitions of what would be a legal description type map with bearings, distances, dimensions. It doesn't have the detail of a grading plan. So the concept is exactly that. The lines can move a little bit. The areas can morph a little bit. That's the concept. Some are detailed concepts, others are bubble plans. This is beyond the bubble plan.
So your conceptual plan could be changed without permission of this board if we approve this conceptual plan, as long as you stay within the exact same amount of units, is what my understanding from your answer.
It can be adjusted, yes, if a pond needs to grow in size or reshape a little bit, yes. I mean, that's the flexibility of being able to get final design construction drawings. But we've taken a little bit further step in that we have construction drawings and they've been approved by the Water Management District.
So then you can probably add in affordable housing, workforce housing, since this is just a conceptual plan, and you can make changes.
Well,
this is not all fee simple stuff, right? You can change that.
The type and the cost of housing,
I'm not asking you the cost. I'm asking you the question of, can you change the condos or your townhomes and make them into affordable or workforce housing? According to your answer, I think you can.
According to the DRI, we're allowed 8 to 10 units per acre of multifamily condos.
I'm talking
quality of the condo,
workforce, affordable housing, because there's not nowhere in here says that, but there also is nothing in here that says you can't change this plan down the road, because your testimony is that you have to come back to this board. I don't believe that's the correct answer. If you wanted to change this conceptual plan, if this is approved, as long as you stay within the number of units, right?
Yes, what I said is that there are two levels. There's staff level of the Growth Management Director has the authority to approve a plan with minor changes, and then this board handles changes that are more than the code allows.
And another question I have that you brought
I do
up.
not know, specifically when you say affordable housing, that's a higher definition of type of housing. Nowhere in the DRI, in the socioeconomic character of that DRI and the development order, does it say what quality of final housing has to be built. It was not intended that this is affordable housing. It's not the intent of this development.
Right, but my question was, you can add it then under your definition of conceptual.
We could under the current DRI approval.
Then you made a statement that that Betts Farmer, you guys own the road. Is that?
No, I said the road is within the Betts Farm DRI, and it was a, quote, Betts Farm Development Road. The county owns the road.
Right.
And the county owns the 70-foot additional property that's been reserved for future widening. But it's a county-owned road now. It was built, paid for, and dedicated to the county by record plat.
No more questions. Thank you.
Mr. Bozeman?
Chuck, let's reference this up here. You've identified areas in green as natural wetlands. Those are currently in existence today?
Yes, sir. We had extensive field surveys done by environmental scientists, including the Water Management District, who visited the site and looked at every single wetland. We had Army Corps of Engineers go to the site and visit the wetlands. They determined the jurisdictional limits of those wetlands. Those were surveyed. That survey was provided to the state. They reviewed it, and they stamped it approved for jurisdiction. So what you see in green is exactly the wetlands that exist. And plus, what's also in green is a 25-foot buffer beyond the jurisdictional wetland line that we would preserve in perpetuity as a 25-foot buffer. Now, I'd point out that our plan that you see actually is based and designed with a 50-foot buffer from the jurisdictional wetland. And part of that is for the back slopes of whether there be fill put in for some of the houses so that they're above the FEMA flood line. So we've got a little bit but they will remain and become buffer right after the fill is put in, they become the buffer.
So as you move forward, and I'm assuming this would be a phased project, I think you indicated somewhat to that effect earlier.
It's not requested as a phased project in this submittal. It would be phase sequence of construction.
That's what I mean, yeah.
Yes, phase sequence of construction. That's why we requested 20 years to give builders time to build.
So it looks like you've clearly designed all of your housing units with the wetlands being undisturbed. I'm not familiar with the topography of this particular project. Where are you going to get the fill to fill the lots, digging retention areas on site?
Some of it comes from the on-site retention ponds, but this design, for the most part, is filling some property and putting the water on top of the fill, so we have filtration, and we're not digging into the aquifer.
So you're going up.
We're going up, not down.
So how much
Most of all of the blue that you see up there are dry retention ponds with grass to provide nutrient uptake and water quality treatment.
Okay, so that's what the blue is. It just isn't labeled, so that's what was confusing.
Blue is the proposed water quality treatment ponds.
And those are where you're going to generate your material to elevate your building pad.
Yes, and because of the FEMA floodplain, rules, we probably will have to truck some dirt in.
You will have to import, I would imagine.
It's just there's not enough on-site. We did not want to dig deep ponds to get dirt to build houses. So some of the dirt will be trucked in.
So you're going to have probably a maximum depth, depending on the existing elevation at surface, how deep you can go.
Right, and in most cases, we're not digging at all. We're building berms between the home sites and the wetlands to stop the water, treat it first, let it trickle slowly into the ground before it could ever get to a wetland.
Okay, that answers my question.
Yes, sir. Mr. Scherer.
Chuck, I've got one more, and I don't understand it, so legitimate question here. On page 168 of our staff report, it's described that construction in the flood zone area complies with FEMA and county standards of at least 1 foot above base flood elevation. And of course, this is an area with some natural wetlands. I don't quite understand what 1 foot above base flood elevation. Explain that to me, would you? What floodplain? What year? Help me out.
Okay, I don't have all the data exactly in front of me, but there's different flood plains by FEMA elevation across the site. I think to the west is elevation 10. I think it gets less. I mean, let's use the word 10 because most of the site is elevation 10. If you want, I can go get my FEMA map.
Oh, is that 10?
But elevation 10, you're required to build your floor 1 foot above the FEMA floodplain. So, out here, we would most likely build the pad for the house around elevation 10, 10 and a half, and then you put your house in and build your foundation, and your floor is at elevation 11. When the DRI was you talk about changes. When the DRI was first approved, and first the elevation was 8. Today, it's 11. I don't know what it's going to be 10 years or 50 years or 100 years from now. But that's why FEMA wants you to go 1 foot above. So most of the site is elevation 10, so the floors would be at elevation 11. Okay. That is the FEMA flood, not the 100-year floodplain. The 100-year floodplain is much less. It's lower.
I'm sorry.
The 100-year floodplain, which is by Land Development Code and Comp Plan, is much lower than FEMA. FEMA addresses surges and hurricanes and tidal waves and all that stuff. FEMA is much higher than the 100-year floodplain.
Okay, good. That was the confusion. I was trying to relate the two, and I didn't know how to do that. All right, thank you. I'm good.
Anyone else?
I just want to clarify.
Speaking to the mic, please, Mr. Dixon.
Yeah, in 2022, the Crystal River High School site was removed from the DRI, so it now is it's now in the comp plan in the LDC as designated for a public, semi-public institutional use. So I just want to make that clear.
Thank you, sir. Anyone else? No? Okay.
Thank you.
Mr. Chair, we did get an alert that someone is parked right in front of the front doors of the building, and they think it's somebody in this room. If it is, please move your car. It's going to be towed. Thank you.
Okay. We're going to take a 10-minute recess. I'm sorry, it's been 2 hours and 19 minutes. Be back at 11:30.
It's very sophisticated.
It's a tricky one.
Town chair.
I would totally be in favor of that. I mean, it took a while just for us to get new chairs. I hate these desks too because it keeps this right here, and then everybody's just kind of all jacked up. Yeah. Just so I'm clear, right? We were done with all the questions. No, he goes after staff is what she said. Yeah, okay. Alrighty. Just to be clear, Madam Attorney, we're in point of order, so finished questions from the board. Intervenor comes last, correct?
Correct.
After
Staff.
staff? Okay.
Yes.
Staff makes their presentation, then intervenor gets to question staff.
Staff does their presentation, both parties, because now you have three parties.
Cross-examine.
Can cross-examine, and then,
Then intervenor.
yes.
Okay.
And then cross-examination of the intervener.
Do we question the intervenor as well?
They're a party just like other
Okay,
parties.
just
so
making
yes.
sure.
Yep.
All right. Okay, here we go. Ms. Katu.
Y'all done with the cross?
Yes, we were done. I'm sorry. I kind of ended abruptly. I was having a hard time sitting here, but we were done with board questions from the applicant.
Floating. Thank you very much. First, I think I need to be recognized as an expert, I think. I'm Joanna Katu. I am the Deputy Growth Management Director for Citrus County. I have a bachelor's degree from Ohio State University, a master's degree from the University of Alberta in Canada. Neither are in planning. They're both in education. I started working for the county in 1995, started studying planning, and I am certified by the American Institute of Certified Planners for the United States. So I don't know who recognizes that, but
Yes, ma'am. I would just say, how long have you been working at Citrus County?
1995.
I won't make you say the years,
Crazy.
but that's not that long ago.
I'm not doing the years.
Great job.
I had a year in New Orleans, 6 months or 9 months or so in Marion County. So
Yeah, okay.
Mostly
I think it's pertinent.
thank you. Okay, so I can proceed.
Yes, ma'am.
All right. So, don't entirely agree with everything Mr. Pigeon said. We have had this application for some time, and we've gone back and forth on a lot of it, but I agree with some of what he said. So we'll talk about that. All right, so this is the application site. It is mostly wooded. You saw a lot of the public input uses the word pristine. Not quite pristine. It is very beautiful, though. There are some old farm buildings on there. Otherwise, it is has not been touched. The history is outlined in the land development in my staff report. 1988 is when this was approved. This is the zoning. Just because it's called a PDR doesn't mean it's a planned unit development. It actually is a DRI, or a development of regional impact. Historically in the state, that was something that was so large and had such far-reaching impacts that the state required additional standards to be recognized. So that happened in 1988. So let's talk a little bit about some of the comments about Turkey Oak while I have this actual map up. I heard talk about Turkey Oak. Mr. Facemeyer had some specific questions as well about that. So when Turkey Oak was constructed, it was required to be constructed because the number of units that were proposed. It was 1,500 in 1988. This was not owned by the county. This was owned by a citizen. At that time, the roadway received impact fee credits for the entire roadway. They've used those. They were all gone. They also had trips. We had a form of concurrency because we had trips that you had to do. You had to do a traffic study, and you had to do this is how many trips are allocated. And one of the things on my history table, in 2006, they transferred some of their vehicle trips to the Nature Walk Affordable Housing Project. That's actually on the other side of Turkey Oak in the city. So there's no trips left here to use. The impact fee credits are long gone. The road was great in 1988 for 1,500 units. It's certainly not now. We don't have concurrency. But we do have access management, and that's why I have some of our public works people here to talk about that and the requirements for turn lanes. I hope that answers that question. I did hear also from Mr. Barmas about the additional access road. It is true that in 1988, I'm stuck. I don't know what that thing is at the top. Thank you. Still won't let me move forward. Thank you. In 1988, we didn't have a requirement for 2 access points. That's been introduced in our code since that time. Now 75 or more units requires 2. So this could not be developed in this way anyway, no matter whether they came forward with before you or not. We would need 2 access points. That's a requirement in our land development code. This is the current plan. Yeah, not beautiful, not very specific. But it does have 1,542 dwelling units. So in that I will agree, they are vested for 1,542 dwelling units. Now a couple changes that they're making. And I tried to point that out. And well, actually we'll go back one. So this is somewhat of the difference. So what they're proposing is less. They're going from 1,542 to 1,466. That's a lot for this development. I don't know if they can accommodate that many reasonably, but they have put it on this plan. Now, the current plan does limit 1,138 are single-family detached and 328 are attached townhome. This proposal has 1,014 for single-family instead of 1,138 and 528 for attached townhome. Now, they also have a condition, which some of you touched on in some of your cross-examination, that they can interchange. So I heard the commitment that they wouldn't actually put some of the condo units over on the west side. They're allowed to do it by the condition that's proposed here is it's interchangeable as long as they say in that number. So don't get too caught up on how many single family and how many townhome because they've added a condition that says that cluster homes are also single family. So technically they could do up to 1,466 single family detached or up to 1,466 townhomes or any mix in between. So you can see the comparison here. That was one thing I wanted to talk about. We heard about the open space. So our commissioners have been very outspoken about open space being used about DRAs being used for open space. You've heard some people come before you and say, oh, it's going to be a soccer field or whatever. And they haven't been that receptive to that. So I did want to point out, and he did confirm that DRAs are proposed as part of their open space as this project. So that's up to you if you want to actually allow that or not. A couple other things that are changing. You can see quite a difference for the single family lot sizes are going quite a bit smaller, but they are adding a minimum width. Right now it doesn't have a minimum width in DRI. Again, this was 1988, long before I was here, but quite different. Staff is proposing a 50-foot. We don't see 40s for single family detached much. Those are usually a townhome kind of thing, but 7,200 to 4,800 is significant. The clusters are similar, 3,200 to 3,200. It's a 20-foot minimum width right now, and they're proposing to go 35, so that is an improvement on that one. And their condo units, there's no minimum lots currently, and they're proposing 2,000 with a 20-foot minimum lot width. So you can see the difference there. The density overall is changing. I heard a lot about impervious surface. Impervious surface right now is 50%, and it can stay, it's proposed as 50%. So there's not a change on that. There is in the open space. So I did want to point out about that one. So there's they're proposing 65, but and 70 is what they're guessing is going to be in those areas, but overall a 50. So they're saying it's going to be the same overall. Setbacks, there's some improvements. Maximum building height is proposed to change to 35. Right now it says it can go up to 45. Now y'all did touch and pick up very, very good. I appreciate you picking it up. This is part of the flood zone. This is an AE flood zone. They are going to have to meet FEMA standards. Turkey Oak is a hurricane evacuation route. All of this is very significant. We need to take that into account. Do they have to come before us to develop this? No. They can take the plan today and run, adding that second access point, but they came before you for some of this relief. And let me go backwards. So, not a lot else to say on this. I tried to talk about some of the things that we're doing. I do want Public Works to come up and talk about the turn lanes. We do think that's required. It's not at all optional for 1,400 units. There's really no choice for a turn lane. Am concerned about the open space and using the DRA areas. You heard about the sidewalk. Our code does not require them to do a sidewalk out to Turkey Oak. I would definitely want to encourage that. Needs to be a walkable community, at least some that to access that. The applicant was not willing to do that. Condition number 11 is actually making interchangeable among cluster and housing at the developer's discretion. So it sounds like that might be something you might want to consider removing. Not at all supporting the zero foot pool enclosures that is proposed to be removed. Unless you don't need Public Works up here, but there is a turn lane that's required here. We know that for the numbers, so I can call them up if you have some questions about Turkey Oak itself and the turn lane requirements. Yes, no, maybe?
I'd like to hear.
I thought so.
I've got questions for him.
Pretend to be an engineer. Or play one on TV or YouTube.
Good morning. Carlton Hall, Public Works. So in some of the recommendations that we made for this many number of homes, we've asked for a turn lane, and that turn lane would be in addition to that 70-foot right-of-way that has been dedicated for the widening of Turkey Oak for future use.
Is there any plans to repair the road currently to make it? The traffic is huge, as we all know, and the road conditions are poor, in my opinion. Is there any plans for technical services to say, hey, other than a turn lane, we need to repair the roads, make it better for the traffic coming through, the school buses, the school traffic, 3,000 plus more cars on Turkey Oak. It's not a vision that I'd like to see. Can you elaborate on that?
We don't have any plans requiring them to do anything with that, but we do have a pavement management program. That road is part of that program since it's county maintained right away, and it's included in that plan for future improvements.
You said the widening. That's why I was more worried if you're going to resurface the road. I understand the road program, but is a road widening in line with this program, this property or application to be done at the same time prior to that? Or just whenever the county feels that it's warranted?
It's not part of this plan. Yeah, they had mentioned that let me find that note. Yeah, they put in the note as needed. But we feel as though the turn lane for this many homes is required.
And are you talking about the 70-foot extension or?
Yes, sir. The turn lanes into the neighborhood in addition to the 70-foot.
In addition to?
Correct.
Thank you.
Anything else for engineering? 'Cause I can't answer those.
Okay.
Carlton, is there plans to, like, upgrade the traffic signal if they build out? Would that be their responsibility?
It would. It'd be evaluated as part of this neighborhood and the impact, and they'll have to do the analysis and bring that forward.
Okay, so that would be the developer's responsibility.
Yeah. Part of that analysis or part of that plan they would bring forward to us to show the impact to that intersection, improvements that would need to be done.
Okay, thank you.
Yes, sir. Mr. Sheriff.
Morning.
Morning.
Are there any changes that you can excuse me, sorry about that. The traffic light currently feeds into Lecanto High School.
Crystal River.
Pardon me. Wrong. Same county, wrong side. Into the Crystal River High School. You see now improvements would be required in that intersection itself due to school traffic, general traffic flow, the addition of the X number of cars the traffic study shows. So do you see changes there?
I believe so. We would require them to bring forward the analysis to show us the impact, and then we would make recommendations based on that.
In those changes, since we don't have traffic concurrency, are those changes part of the developer's burden, cost burden, or are those part of the county?
I'm not sure about that at this time.
Okay, thank you.
Mr. Bozeman.
Has the the DOT had all been brought into the conversation only because of Turkey Oak's connection to State Road 44. I know it connects to Citrus Avenue and also to 490, whatever the road is. It goes up to DeRosa. Yeah, DeRosa.
Not that I'm aware of, no.
Because where Turkey Oak intersects with State Road 44, I believe there's only a caution light there.
Yeah, not that I'm aware of.
Okay.
No, it's a stoplight there.
Yeah.
At 44 in Turkey Oak is definitely a stoplight.
I don't go that way much.
So I'm just curious, for my own knowledge, at what point do you guys determine what is the indicating factor, the leading factor that would say, okay, this road needs to be widened?
I believe we would do the use of the road, congestion of the road. We would do our own studies to look at that to see when it tripped or triggered widening or increasing capacity.
Do you know when the last time that study was done for that particular road?
No, I do not.
I would suggest that you study that road because I travel that area. My kids are in school there. I live in that area. My office is in that area. The road backed up from 44 to Turkey Oak. I've seen it backed up nearly as far as Holiday Drive recently. And I've lived here my entire life. I've never seen that before in my entire life. It takes 5, 6, 7, 8 lights to get through that intersection right now with a one single turn lane going left, which would be east on 44, and one right-hand lane, which can either take you across 44 over there or west on 44. It's beyond needing studied, in my opinion. I'm just using this platform to tell you that. I'm not pointing fingers. We're all here. It's an open conversation.
Absolutely.
I can tell you that. All right, I'll save that part. Never mind. Anybody else have any questions?
Not for Carlton, no.
No? Okay. Thank you, sir. I appreciate your time.
Is there any cross?
Hang on. We're not done, right? Do you? Okay. I was just making sure we were. Were you done with everybody that you had bringing up? Like, do we want to cross-examine them individually? I guess because we did, we should allow the applicant and the intervener to cross-examine at the same time. You guys okay with that?
I'm okay with that, but I still have questions for Joe.
Yeah, right. Understood. Right. So we know that she's.
Questions for Joanna. Let him do that.
Okay.
Understood.
All right.
Okay.
What-
All right, I think I'm ready.
You'll get your opportunity. You'll get your opportunity. Okay, perfect. Just make sure we're all clear.
And I didn't go over all the conditions. I can do so if you like. You've seen them. Reducing it to 1,466 units from 1,542. The access management standards are the ones that engineering have specified. They do need turn lanes. They need a signalized intersection, examining the signalized intersection for the connection on Turkey Oak. That's one of the conditions. Updated signal warrant and turn lane warrants for each phase. Perpetual drainage easement needs to be shown. The buffer zones, that the buffers can be allowed as open space, and that's up to you if you want to allow them to include DRAs or not. Staff does not support that. Developer shall incorporate in there some wetland areas. That's in the existing DRA. They are proposing to, they actually cleaned up that language quite a bit with the existing DRI, and I've lost it. I'm sorry, I moved around here too much. They are keeping the condition about meeting standards. There's a potential for karst-related subsidence, so they do have to meet that with swift mud, any criteria. They are proposing to be served by central water and sewer provided by Citrus County. There is some notations about the southeastern kestrel, gopher tortoises, and Sherman's fox squirrel. They do appear to be at least some of those species on site, so they will need a biosurvey. Condition about 100-foot radius around any active southeastern kestrel nest during this breeding season. That was discovered in 1988. They may not still be there, but if they are, they have to meet that condition. That's an existing condition. Condition number 10, that there's a 50-foot buffer around the perimeter of development. Now, they have added quite a lot of clarification on that. I do appreciate it. As he said, it did say just a natural buffer, which told me nothing. So they have done a additional scrub plantings will be required for gaps in visual screens, 6 trees per 100 linear feet with a visual screen of 36 inches in height after 1 year. And that was along Turkey Oak. For the remainder, 2 trees per 100 linear feet with shrubs, creating a visual screen of 24 inches after 1 year. All that is additional language. Wonderful. I'm glad they have that. Condition number 11 is the existing language about interchangeability. They've actually put in even a little bit more than that, because condition 12 says detached are also included in cluster houses. Again, that's up to you if you want to include that. A building separation of 10 feet is proposed condition 13. Condition 14 are the development standards I had on my slide. That's where the minimum lot width of 40 foot or 50 feet came into play. Just about done. The sidewalks I actually talked about. I would like to change that, to amend that to require them to access Turkey Oak. They are proposing to extend the build date and expiration date of the DRI from 2029 to 20 years from the date of approval of the Board of County Commissioners. Condition 17 says 10 acres of open space of active and passive recreation. That's not currently in there. Condition 19, signage must be LDC, and condition 20, fencing and walls must meet the criteria of the Land Development Code or the county engineer or building official, depending on where the signage is. Sorry about that. Now I can answer questions.
Mr. Bozeman?
And have they agreed to these conditions?
Not all of them. So not the turn lane one, not the sidewalk one. It didn't sound like they were, or the buffer zone areas, including open DRAs. So we have a few that are still not. So I would say condition 2, access management, F is not in agreement. Condition 4, they do want to allow open areas to include DRAs. And there were a few.
Is that not already allowable?
No, in a PUD you have to ask for permission for that.
Mr. Shara?
Morning, Joanna.
Morning.
Nine short.
Afternoon, I think, yeah.
Not quite, almost.
Okay.
So, 10,000-foot question. The applicant represented that they can go with the existing DRI as it's been modified over time, that they can go build 1,542 units. And the inference was, we have all the approvals we need except for the specific, approvals to construct. That was an inference of my interpretation. You agree with that?
Not in this format. They would need the deviations that they're putting in these conditions. So yes, they have the ability. It's a DRI. They can come in today and start platting 1,500 units, but they have to meet the conditions that are already in place and not the ones that they're proposing. So there are some changes in there.
Okay, so they really don't have, at this point, the ability to come in today, advise you they're going to begin platting and construction without further compliance with these particular types of conditions.
They'd have to meet the existing conditions and not this master plan. I mean, yeah.
You agree that the DRI requirements that'll go into this PUD with these variances meet the current standards? In other words, that they're not aged based upon outdated, the DRI components and conditions are not outdated. They meet the current standards as if
Right.
this was a fresh application today.
Yeah, so I heard the question of, is the DRI been kept up to date? It has. It's not expired and everything is current. The one access point doesn't meet our code. That's a good example of how it does not. Many of these are things that came up in normal DRIs. I don't see anything that opposes the code other than that very obvious access point.
If I could ask you just a couple more.
Sure. No, you're fine.
I asked the applicant about location of townhomes and multifamily homes. And we've had these discussions with other people in the past about compatibility in particular. Basically, my interpretation of what he told me was they're not going to make a commitment that the townhomes and multifamily homes, multi-story homes are going to be located in that particular area. In your interpretation, do we have any issues with compatibility with the existing home sites and parcels if they would elect to move them to another part of the site?
Well, understanding that they are vested for that many units, but you're correct. That's why staff was proposing at least a 50-foot minimum width. One thing I will point out that I didn't is, if I can get this to work, I don't know where I'm pushing to. I'm pushing on yours and nothing else. Okay, top left-hand corner of the plan, there's a little access point going off to the lands there to the west. That's actually residential lands. There's no road there. I don't know what's happening there either. I don't know how to answer your question really, really well. Compatibility is a concern. 1,500 units anywhere is a concern, but on the books they have 1,500 units. I guess that's the best I can say is I can't say, nope, no longer 1,500 goes away. That's not something that's in my ability to do.
I can understand that. In your comments, in your report, you state that there have been certain verbal representations by the applicant. Have you captured those verbal representations in your conditions?
I tried to, yes. I didn't get agreement on a couple of them, but it sounds like he's okay with the 0 for pool enclosures, accessory structures going away, which was good. And he is willing to commit to the 89.2 acres of open space, but also including that as DRA. So part of that. But yeah, those are the only two I think that were changed from what he was saying.
So just a quick touch, it wouldn't be a meeting without a discussion of intensity and ISR. We've had this discussion on other projects. 50% site-wide average ISR appears to be acceptable to the county based upon the 65% and the 70%.
Don't like it all, the 65 and the 70. Don't like that at all. What's existing already is 50% site-wide. So it's already in place. So saying that's too much now, it's already there, whether y'all approve it or not. They have that. That's all I was trying to say. 65 and 70 are crazy, but there's so much wetlands and so much area. Well, not the wetlands. There's so much open drainage areas there that they feel they can prove 50%, which is required now.
So I saw their calculations attempting to demonstrate that they can meet the
right
less than 50% based on 70% intensity or ISR. Did you take a look at that calculation?
I did, and that's actually at my request. I was like, I don't think you can do 50 here. I was pretty flat out. And they're engineers, and good for them. They gave me those calculations to try to support that they feel they can.
And part of that ISR calculation is the DRA?
Yes, you can include in ISR, not non-wet, so dry DRAs, yes. Non-wet,
quick
new
second.
word.
The one that confuses me the most is your condition 11, related to not just the 50-foot buffer, but also related to trees. And so my question is going to be, we now have a tree preservation plan that didn't exist in 1988. So does condition 11, and my computer's acting up for a second.
I think it's 10, but yeah.
Give me a second.
It is 10.
Is this 10?
Yes.
Yeah, thank you for that.
All right.
So condition 10, with the added language, has the applicant agreed with your underlying language?
That's actually written by the applicant.
Okay.
Right now, all it says is, we'll give you 10 foot of landscaping as a buffer, which tells me absolutely nothing. Is that an A? Is that a D? I don't know what that is. So they added all this with a discussion based on other applications. This is somewhat similar. So this is actually an improvement from the existing, this particular condition.
So in your opinion, expert as it is,
Expert.
do you agree that this language is sufficient to take into consideration our tree preservation plan, preservation of trees of significance and others?
This is just a perimeter buffer. So this is not talking about interior. This is a perimeter buffer, and it's wonderful, wonderful language for perimeter buffer, yes.
Okay. All right. I'm going to stop.
It's all right. You always have good questions.
Joanna, if I wanted to go build a house today on a particular piece of property that was zoned, excuse me, residential, how many feet away would I need to be from a wetland?
35.
35 feet? What are they proposing in this?
They are proposing that, let's see. Condition number 5, they're saying no building setbacks from wetlands shall be 35 feet. Lot grading shall be 15 feet. And that both of those are consistent with the Land Development Code and Comprehensive Plan.
Okay.
Now, they do say they're going to impact some wetlands, very minimal according to this, but they are going to impact some.
Yeah, I saw that on the one slide that they have, that little red area. I think it said 0.37 of an acre. If I was going to build a home on a piece of property and I wanted to disturb 0.5% of wetlands on the particular property, what would happen?
You would have to go through the state and get approval for that. Not an easy thing.
Is that what they're going to have to do?
Yes.
So they would have to go through the same thing. That's not just based on what we say here.
No, we do not have jurisdiction over wetlands. We
Okay.
do on our development, but that's the state's.
Does the state? What's the state stance typically? I mean, we can't say typically. That's probably the way wrong word. But like, how does that process work?
I've seen them.
Mitigation, things like that.
Yes, there's mitigation banks, etc. Yeah, there's a lot of options, and I'm not that familiar with it other than I see the approvals.
Right. Okay. Anyone else?
I just have, just for clarity, can we add a condition that makes it clear that if the traffic signal has to be upgraded based on the traffic counts, that it's their responsibility to pay for that?
I think, so condition 2K says, any turn lane improvements or modifications to the traffic signal or pedestrian facilities in the county right-of-way will need to be constructed by the developer at time of development. So I think we've got it in there.
Okay. And they will connect to the sidewalk?
They're not proposing that. That's something staff thinks that we should put in as a condition, but they did not agree to that.
I think we should put that in as a condition.
Agreed.
I hope the rest of the board does too, because that's a current requirement and they're developing it in real time, so they need to.
Walking to school is a thing, yep.
We spent a lot of money to put that sidewalk there, and so it needs to be used.
Agreed.
Anyone else?
No.
No. Okay, so we questions, cross-examination from the applicant.
Yes, sir, Mr. Chairman, just for clarity, Mr. Dixon, yes, it's already in here that any improvements to the traffic signals, any improvements to the roadways are the responsibility of the developer. In the conditions, Ms. Joanna, it does state that we must do a signal warrant study for each phase of development. That's a condition. Is that one of the conditions in here? That we must do a traffic signal warrant study for each phase? I believe it's.
Are you asking me if it's a condition?
Correct, just for clarity that there.
Yeah, I don't know if that, okay. So condition 2J, if the project is constructed in phases, updated signal warrant and turn lane warrants will be required with each phase, yes.
Correct. And it says at the time of development, item E, a turn lane warrant analysis is required for any proposed connections to Turkey Oak Drive. Item E.
Yes.
And you already answered the question about who pays for it, if it's required to be warranted. I just want to be clear, and maybe it's a question, we intend fully that based on sound engineering practices, we'll be building a turn lane. You never do a project without a turn lane. The question is, on this condition that we asked to meet the comprehensive plan language, was that it wouldn't automatically today, with a condition, say if a turn lane is put in, and we expect one to be put in, that we must dedicate right-of-way to the county. All we're asking for is the language in the code that said when the turn lane is constructed, if we do not need additional right-of-way, we don't have to dedicate additional right-of-way. We fully intend on constructing turn lanes.
Obviously, we want dedication. They have to give their land for their turn lane, not our right of way, but have at it.
Yeah, that's correct. I mean, if it's going to impact, the turn lane's going to have to be put in, right away is going to have to be given to the county for that.
So, in your expert testimony.
That's the disagreement there.
Mr. McCall, in your expert testimony, you are making a decision today that's saying additional right-of-way is required if a turn lane goes in. Could you explain why it would be required?
I can bring the assistant county engineer up to answer more, but.
Why is everybody looking at me? No, I mean, if the county staff is requiring it, county staff is requiring it. I don't know what to say.
Okay, just have a word, Mr. Chairman. The point being is the county
This
is
is cross-examination, not testimony.
Okay, thank you, ma'am. One question then. The 70-foot additional right-of-way, in addition to the 80-foot right-of-way that has been reserved by the county, is that for the purposes of adding additional lanes, which could include turn lanes?
Possibly, just depends on the evaluation of the road at that time, but the 70 feet is to just expand the roadway itself. The turn lanes would be in addition to that.
And one last question. To your knowledge, is there already water systems, sewer systems, and electric systems already in place in the 80-foot right-of-way? So therefore, additional right-of-way would not be needed to add or build those at this time?
I'm not aware where the water or any of that is at now.
Thank you.
I don't know if the intervener has any.
Well, has Mr. Pigeon done?
One last
I said one
question.
last, sorry.
Just one last question. The current DRI, the current resolution, and the current requirements require, to my knowledge and to my previous testimony, that sidewalks are required. Those sidewalks connect to Turkey Oak. Is that true? Is that the current PUD and the current DRI require sidewalks on the major collector roadways which connect to Turkey Oak?
The current DRI requires sidewalks for the collector roadway.
Yes.
Yes.
Okay, thank you.
Okay.
So the comment about sidewalks, that you want to require sidewalks, what you're saying is they are already required. So we're not opposed to sidewalks.
Want them to connect to Turkey Oak as well, not just a collector roadway. They need to collect to Turkey Oak.
And the collectors connect to Turkey. Is that correct? Okay, thank you, ma'am. That's all.
Thank you, sir. Yes, sir.
Do you care which mic?
It's okay, Joanna. No, this actually, I don't have any questions. I actually have questions for your Public Works Department.
You might want to introduce yourself because you haven't spoken yet.
Thank you, Ms. Diamond. I'm terribly sorry. Hello, Board. Michael Hill, Torreya Design out of Gainesville, Florida. Like I said, I'm just a land use consultant hired by people in the community. I'm just here today to ask one quick question for you. So, sir, remind me your name. Your name's Chuck, correct?
Carlton Hall.
Carlton, sorry. I don't know why I thought Chuck. Mr. Hall, a question for you regarding this project. So, as you see, the DRI initially approved for 50% impervious. They're proposing 65. Now, I have seen several pictures that members of the public have sent me about the roadway there on Turkey Oak Drive flooding. Now, when I look at an increase of impervious to 65% ISR, you know, again, not a civil engineer, don't have a license, not claiming on the record to be an engineer, but again, the two things I know is that when you have impervious, that displaces water, and there's no water here, Turkey Oak floods. So I wanted to ask you, as an engineer with your expertise, what do you think could potentially happen to the flooding problems on Turkey Oak Road if the 65% is granted?
Just to set the record straight, I'm not an engineer, but we do have the assistant county engineer here that might be able to answer that question.
Mr. Hall, could we ask him if it's possible? My apologies. I thought you were an engineer.
I would also say that I believe that the project is still staying at 50%. It's granted for 50 or vested for 50, staying at 50.
Well,
he's mentioning 65%. I just want to make sure we got the record clear.
Okay, yeah, because I saw that it said that it was proposing to go to 65%.
They were talking about on some of the lots. Ms. Katu brought that point up. If you want to bring that up again.
So I know this is our cross. So
Yeah.
They are asking for 55% overall, and individually in some of the areas will be 65 and 70, but they will be demonstrating 50% overall.
Okay. Well, then here, my question is just for the county engineer. Sir, question. Now, regards with the numbers and... Can I introduce myself? Yeah, go ahead. I'm sorry. I'm so sorry. Well, it's almost good evening, Commission. Yes, it's getting there. Corey Dillmore. I'm the Director of Utility Planning and Engineering for the county. I am also the Assistant County Engineer, about 25 years experience in civil engineering, about half and half split between private and public sector. All right, and your question was regards to stormwater. Yeah, kind of, because Corey, like my problem that I'm wondering is that I'm seeing these videos basically of the roads flooding right now with nothing there, and I'm seeing that that some parts of the project are going to 65% impervious, where it's going 55 overall. I'm going to ask you, because again, I know that they have to submit a drainage report to you, and you have to review that. I mean, again, not an engineer, but I'm seeing that, okay, they're adding more impervious, the road already floods. How are they going to alleviate the road from not, how are they going to alleviate from exacerbating that flooding on Turkey Oak already, as it is already? Well, as the engineer who's developing the site must design that site to accommodate for pre and post development flows. Okay. So typically the rate of discharge of that site is held to pre-development levels. Okay. So by the nature of installing DRAs on site or stormwater treatment, you are retaining that water, that the additional runoff from your proposed impervious on site, which allows treatment. Okay. So in accordance with state regulations, DEP, Southwest Florida Water Management District, ERP. Yeah. I can't speak in detail on that because I have not designed the site and the impervious area, but that is the intent of the engineered drainage system. Okay. One more question, then I'll leave you alone, Corey. When I'm assuming they submitted a geotechnical report to you guys. Let me ask you a question. Where they are showing the proposed DRAs, what were the soil samples in those areas? I have not reviewed any geotechnical for this site. Yeah, because I have heard, and again, not claiming to be an engineer, but I've heard like if you have something like muck there, it's not going to percolate well. I'm not.
Now I've got someone testify. Mr. Bill wants to testify later. He's going to get that chance. Right now he's testifying and mixing that into his cross and playing that game. The line, I know this is QJ, we're not in court, but your ordinance says that cross shall be, related to the rest.
Cannot hear what he said.
Share. Yeah, there you go. Share the mic.
So cross-examination is supposed to be related to direct. He hasn't even done his presentation yet. He's mixing pieces of his presentation, which he has every right to give, into his cross of county staff, which puts me at a disadvantage because I either got to stand up and object and everyone in the room is going to hate me in about 2 minutes, or we do things in the right procedure and the right line and let him present as he has a right to do. But let's not mix testimony with cross. He says, I've seen pictures, I've done this, I've done that, I've heard this. A is speculative, which is not competent substantial evidence, and B, it's argument, which is we're not in the right period for.
I would agree. If you have questions for your cross-examination, please keep them, but your statements, keep them to yourself. You're going to get your opportunity to present.
Yes, Mr. Chair. Like I said, I just had those 2 questions about whether he looked at the soils and whether
Were they answered?
Yeah, they were. That's
Okay,
what I
thank
said.
you.
I'm done. Like I said, I have no more questions after that.
Thank you, sir.
That's all I wanted to know.
Yep, no problem. Thank you. Okay, so do we have any additional questions from the board?
Yeah, I got one for you, Joanne. Just on a condition, what was it? J. They use the word if the project is constructed in phases, an updated signal warrants the turn lane. Why is the word if the project is constructed in phases? Shouldn't that be site overall, not just if it's in phases? It should be totally in.
Well, the other bullet points already have that we have to do that, but if they choose to do it in phases, because we don't know if it's going to be phased or not, we have no information. That says if it's phased, you also have to do it with each phase, but it's also in there on the other bullet points that they have to do it anyway. The signal warrant analysis is required. So they either have to do K, they have to do it, they have to do I, a signal warrant analysis is required. So we've covered it otherwise, but this kind of says, but if you're doing it in phases, you still got to do it by phase. You don't get out of it.
Right. Okay. Thank you.
Mm-hmm.
Anyone else? Seeing none? Thank you.
Clear as mud.
Yes. Mr. Hill?
Mr. Chair, my client's going to introduce me, and she and her team also have some things that she want to use in our 30 minutes. So I'll let her talk.
I'm introducing Michael Hill to be our intervener, and my husband, Ed Lukasik, will also be giving some statements with regard to this project, and he will explain what his experience is when he comes up.
Thank you, ma'am.
Mr. Chair, Board. Oh, can you hear me? Okay. Mr. Chair, Board, again, Michael Hill. I am the principal of Torreya Design and Consulting. We are a private land use firm out of Gainesville, Florida. I've been an urban planner for about 3.5 years. I have a bachelor's degree in history from the University of Florida with a minor in urban planning. I have actually served on an advisory board for going on while in college about 4.5, 5 years. I'm gonna tell you right now, I've done my fair share of development, everything from small modifications to planned developments. If you want to go down to South Florida, I'll show you some of the projects that I worked on and approve. Now, I'm going to give a small analysis just on this application from what I've seen from the planning and zoning end. So first off, now, the applicant notated specifically in section 4300, which, as you know, by the Citrus County Land Development Code, is the section for planned developments, which is what this is. This is they're going PUD. 4303 says general standards for planned unit developments. When I read that, I don't interpret that as an okay. You can choose whether to meet these or not. So I want to first put it on the record that general standards does not mean that these are optional. Okay, and when you read those general standards, one of those is that landscape design and maintenance must adhere to the Florida Friendly Guidelines and the Florida Friendly Yards Program. I am a Florida Friendly Certified Landscape Professional. I've sent you my credentials. You can look me up on the IFAS search tool. I'm here and I have that. Now, when I look at this project, yes, they did offer perimeter buffering. That's great. That's a good start. But here's my issue with that. We don't have a bona fide landscape plan provided by either an LA or a landscape designer. Some cities and some counties allow landscape designers. Some just require the landscape architects. There's no landscape plan. How can we say here that this project is going to adhere to the Florida Friendly Landscaping Guidelines and Principles, which I have notated in my staff report to you guys? Granted, you know, the argument could be made that probably they're meeting some, but they have to meet all 9 principles to be certified Florida Friendly. For an example, when I was in South Florida doing reviews, and I would apply the principles, and my bosses in our planning department, they encouraged me to do that. A lot of developers would come to me and said, Mike, here's our HOA bylaws and docs that we're proposing for this planned development. Look at the landscaping section on this page. Tell us what you think. And I would help them craft language to ensure that even once they developed it, they had strict guidelines in their HOA docs to ensure that all properties and all houses had Florida-friendly landscaping. Because as you guys know, Florida-friendly landscaping has a bunch of positive effects on the environment, and it also protects our waterways. Again, like I've said here, there's no landscape plan. That means it is not meeting Section 4303. That right there means this is not a complete application. Another point I want to make is that, again, with my cross to the assistant county engineer, there's not even a geotechnical report that's been pro. So how do we know that the ponds are going to percolate? How do we know that? We usually an engineer will determine that based on the soils. If there's no geotechnical report, how is this county engineer going to make that determination? The road, like I said, the road already floods. Again, with the information now that basically on top of the fact that we need to protect the floodplain, the road floods already. There's hundreds of videos that have been sent to the county and to you guys about that. And now that there's no geotechnical report part of the application, this application's incomplete and it should be denied. And that's all I'm going to say for you guys today. They need to go back to the drawing board. If they want to bring a full and complete application and review it, we will do that. But right now, how it stands, this application is not complete. Now, I'll give over the board to my client for her to talk. And one more thing I want to state for the record. My client lives within proximity of this property. So if anybody is questioning the intervener, I filled it out for her because, again, like I said, she has hired me as her consultant, so I will take care of the official paperwork. But my client lives next to this project, just so you're aware. Angela, Ed, you want to come up?
If you don't mind, I'm just going to read what I wrote. Crystal River Kings Bay is a first magnitude spring system comprised of over 70 springs. It's the second largest springs group in Florida. The Kings Bay spring shed is approximately 310 square miles and covers a significant Citrus County land area. The comp plan, Chapter 3, contains several sections protecting our springs. Policy 3.16.13 discourages wetland alterations within a karst-sensitive area, as delineated by Florida's Environmental Assessment and Vulnerability Index. Betts Farm within the karst-sensitive area per the FDEP geological map of the state of Florida, it's located, or should I say Betts Farm is located in priority 1, 2, and 3 recharge areas per the Florida Natural Areas Inventory. Priority 1 is the highest value for critical recharge areas for springs, sinks, aquifers, or other natural systems or public water supply. Betts Farm has 3 previously identified sinkholes in the original DRI, resolution number 8829, executed development of order from March 1st, 1988. Not mentioned in the Bravo Land Group amended DRI or its Swift Mud permit applications. There are documented photos from 1994 from a Swift Mud inspection of these sinkholes. Direct communication from surface water to the springs per the groundwater tables are in Adora's hydrology report. All of these are indicators of sensitive karst. The Adora report states construction might cause immediate water quality degradation in the first magnitude springs. Policy 3.18.6F doesn't allow the use of sensitive karst features, including sinkholes with a direct connection to the aquifer, or stream-to-sink features for stormwater management facilities. Per the original DRI, the amended DRI doesn't address sinkhole mitigation for direct connections to the Floridan aquifer that includes stormwater retention basins, monitoring after significant storms, installing groundwater quality, monitoring network up and down gradient of detention retention basins, and reporting sinkholes to the Florida Sinkhole Research Institute at the University of Central Florida. Policy 3.17.5 of the Comprehensive Plan requires all new subdivisions to preserve and dedicate adequate open space. Open space standards shall be defined as defined in Policy 17.15.11. 80 acres out of 348.2 acres for open space isn't enough. The original DRI set aside 165 acres for parks and natural areas. Additionally, no constructed drainage retention areas will be used or counted toward meeting the active recreational needs. No electric utility transmission line right-of-way shall be counted toward the recreation open space requirements. The amended DRI application doesn't allow enough open space. It doesn't ensure any habitat preservation, including a mature forest canopy or integrity of the aquifer. The original Betts Farm DRI was 500 acres, a 1,500 unit residential development, 108 acres of open space. The amended DRI application is 348.2 acres with 1,466 dwelling units, open space, and recreation areas. That's 151.8 acres less than the original DRI. Specified lot widths are 20 feet to 40 feet, lacking specificity. It's high density, which doesn't fit the aesthetic of the existing rural area. Per the original DRI, no extraction of any mineral resources on site other than normal practices for residential development. Bravo Land Group's Swift Mud permit is for mass grading stormwater management. The language is unclear to earthwork balance calculations. Some typical cross-sections of ponds show the original ground elevation at 27 feet with a pond floor elevation of 11 feet. Simple math, 16 feet of material will be removed. The intentions are unclear. The original DRI prohibits extraction. No reference in the amended DRI to preserve a pristine state. In a pristine state, a small circular wetland system surrounded by a thin fringe of cypress near the south central portion of the Betts Farm site, as described on page 18-31 Betts Farm. It contains threatened southeastern kestrel habitat. The amended DRI doesn't mention the developer will preserve all snags, dead tree limbs, and dead trees within the buffers, open spaces, and passive recreation areas. The Sandhill site has large populations of gopher frogs and gopher tortoises. Its habitat for the southeastern kestrel and Sherman's fox squirrel. The state identified 40 to 50 acres of Betts Farm to preserve this habitat. The amended DRI lacks this information. Preserving mature pine and oak trees 12 inches or greater throughout the Betts Farm DRI site to provide Sherman's fox squirrels forage and nesting sites in cooperation with the state. There are very mature live oaks and pines on this property. Clear cutting is unacceptable. Policy 3.9.10 protects the native tree canopy. The Ardora Wildlife Report lacks details in its findings. Betts Farm falls under Policy 3.9.6. The gopher tortoise was uplisted by the International Union for Conservation of Nature from vulnerable to critically endangered. It's at extremely high risk of extinction, with approximately 80% population declines over 120 years. That's 3 tortoise generations. Policy 3.9.5 applies to Betts Farm. Is this the legacy Citrus County wants for the Nature Coast? Please deny this application.
Good afternoon. Can you hear me?
We can hear you.
Okay. Good afternoon. My name is Ed. Last name Lukasek, Lukacsek. My background is I'm a retired, multi-state licensed civil structural engineer. I've only been doing this gig for 40 years. I'm just a mere neophyte compared to the guys here for 44 or however many years these guys are doing. So my background is in terms of roadway work, highway work, structural work. I've also worked for consultants that were design consultants of choice for large nationwide retailers. We put together site plans. We put together traffic plans. We didn't have these questions when we went to a board. We had the answers set and ready to go. We knew where our entrances were. We knew where our exits were. In this case, where we're adding 2 new entrances, you're putting those entrances on a curve. You're putting on an existing curved roadway. The existing existing signal is on a tangent section. So you really don't want turn lanes and extra turnoffs on curved sections. It affects the sight distance, and at nighttime, the sight distance is not very good. I drive it on a regular basis, given that I live in the area. The other factor that's in here, that entrance to the school, there are 1,249 approximately students as of, I think it was 23. And a good portion of those students are allowed to drive if they maintain a certain grade point average. They're entitled to take their car to school and park there. I don't know if they're using the Turkey Oak entrance or the other entrance, but they are students driving, which are not the most experienced drivers either. So that enters into the equation. So in general, I have a more prepared statement. I just wanted to address those few things. Angela already talked about the sensitive karst and the 3 sinkholes that are documented in the Swift Mud Permit documents per Citrus County Book 781, page 2158. And on the project documents, wetlands A, B, C, H, and I are considered open basins with flow to Crystal River per the Ardura and Swift Mud hydrology worksheets. Sensitive karst locations are shown on the Florida DEP GIS maps of Citrus County at the Betts Farm site. That's for the entire aquifer in the whole area. There is a UES geotechnical boring that was included, and the borings show weathered limestone from 2.5 feet deep to 13.5 feet deep below grade. So again, weathered limestone, beginning of karst, which is friable, potentially. Sensitive karst is friable, breaks up, turns into sand. And a quote from the UES geotechnical report was that it is important to note that the upper in situ soil zone is usually heavily altered by heavy vibrating earthwork equipment, and that's signed and sealed by 2 PEs, Kwiatkowski and Suarez. The Ardura executive summary states that earthwork will consist of both excavation and soil compaction operations, which fits into what the quote from the UES geotechnical report says. And in terms of what Michael already mentioned as far as soil reports, all I saw were borings. I didn't see specific soil gradations and evaluations. So the borings were important for the karst. All the above conditions indicate the presence of sensitive karst and that it is shallow enough to be easily and irreparably damaged. Friable karst particles can be easily washed into the 600 million gallon per day Kings Bay first magnitude spring shed, thereby creating additional sinkholes at the Betts Farm site and in the general area. And just to bring you up to remind you, last week on State Road 19, not too far away from this site, there's a large sinkhole right in the middle of the road. And it was closed, I think, for most of the afternoon. They had a picture online. I just saw it was like about a 4-foot diameter hole. And you could see the karst right from the picture from a distance. So that's one of the problems, as these things progress. I'd also like to bring up the hydrologic impacts of the massive FDOT tollway turnpike. Nobody's brought that up so far in this whole procedure. Nowhere in the Betts Farm permit is the FDOT tollway drainage pattern where it's considered. It's very close to the Betts Farm site. And there are already areas where what was built is washing away. They don't have just the sand hills. If it's properly constructed, there's supposed to be drainage on the pavement and drainage into inlets and drainage structures, and it's supposed to go out through pipes to designated designed areas. Where in fact, after these rains, the drainage is not going in those locations and it's washing out entire sides of slopes on the FDOT Parkway. So if that happens in the vicinity of Betts Farm, we've got a lot of water that's potentially going where it's not supposed to go. Just a fact. And the tollway will cause significant impact to just the overall aerial stormwater effects, given the fact that Turkey Oak Road is already in bad shape, not draining too well, flooding at reasonable intervals. And after the hurricane, for sure, there was over 3 to 4 feet of water on that road. And the traffic report that was submitted was a hurricane evacuation study. Well, that was in 2024, right before the hurricane. And basically that flooded roadway pretty much negates whatever they came up with as far as evacuating the area, because there was no evacuation going on through 4 feet of water. And the other factor, the tollway will also significantly impact the Florida and aquifer recharge quantities and the recharge calculations by water groups and the regulators. That also is affected by Betts Farm recharge into that aquifer. As things are tampered with on the surface, that affects the recharge. That hasn't been brought up. Now I'd like to go to points in the comp plan. And the comp plan requirements for parks, Chapter 2, combined with the transportation in Chapter 10. Some of these, it might seem like they're not directly related to Betts Farm, but please bear with me and you'll see why I talk about it. Chapter 2, Goal 2, provide a variety of parks, recreation facilities, and programs. Policy 2.1.2, the county shall develop individual park plans and recreational facilities suitable to the needs of the residents based upon user needs and demand. Policy 2.1.6, the county shall consider citizen input in order to assess parks and recreational community needs. And goal 10, provide safe and convenient bicycle, sidewalk, and multi-use trails. Policy 10A 1.1, identify multimodal corridors and activity centers. Small area plans to increase connectivity. These are all parts of the comp plan. Policy 10A 1.2, identify and provide for special land use needs within the Suncoast Parkway corridor and special aerial plans for IMAs, interchange management areas. That's to manage, the design is to maximize positive Suncoast economic impact. The parkway includes a bike trail and a huge land clearing operation that has occurred for bikeway trailhead and car parking lots. and this will require multi-use trails to connect the Crystal River downtown area and the city trail, and that will have to go along Citrus Avenue. Right now, there are many subdivisions along Citrus Avenue that are isolated, and according to this comp plan goal requirements, a trail along Citrus Avenue would connect these together with multimodal transportation facilities, which is what we're supposed to be doing. And the reason I bring this all up is Betts Farm would be the ideal location for a centralized bike trail connector hub and multi-use park and recreation area. And this recreation area, and it has been demanded by Citrus County taxpayers and ignored by the BOCC with this whole Betts Farm situation. Policy 10A 1.4 requires developments submit a circulation, parking, bicycle, pedestrian, and access plan prior to the issuance of any development order. Policy 10A 2.2, the county shall update Chapter 7 of the Land Development Code, Transportation Standards, to include the provision of bicycle and pedestrian facilities in the planning and the design of transportation facilities, namely Citrus Avenue corridors and major collectors, which it is a major collector north of Turkey Oak connecting the FDOT Parkway with Crystal River. So those are all required by the comp plan. The other thing that I would address is on the DRI open space with allowing the open drainage areas as open spaces and play areas for kids. I know I wouldn't want my kids playing in those. All I see is the birds eating whatever congregates in those ponds, and you know what birds do after they eat, and I wouldn't want my kids playing in that area. And that's what's happening. We're making an open sewer a play area. That's a no-go, no bueno. I think for the most part that's about it. Thank you very much for your attention. Board, I will make one more comment and then I will end my presentation. One more thing that I want to also bring to your attention, and again, it goes back to the landscape plan. In my time in reviewing development in this state, most invasive exotic plants that are overrunning our natural areas in Florida were all introduced in subdivisions. They were sold by retailers, planted in people's yards, and then they went crazy into the natural areas. Your planning departments, and when they review landscape plans, they are what I say the line. Because believe it or not, next to development, invasive exotic plants is like next on the list for destroying natural areas. If a landscape plan is not provided with this application, how do we know that what they're saying is native is actually native? Because I have had a landscape architect tell me that a bromeliad that grows native to Vietnam is native to Florida. And I had to tell him, well, that doesn't meet the state's definition in 5B40 of the Florida Administrative Code. And he said, you're right, Michael, I'm going to remove it from the landscape plan. Thank you, sir. So I'm just saying the landscape plan is a very important component. It's required in the general requirements of the PUD process in your land development code, and no such plan exists in this application. It is inefficient, and it should be denied based on that and everything that my client has just brought into the record. Thank you for your time.
Thank you. Staff,
No
cross-examination of the intervener?
No, thank you, sir.
Applicant, cross-examination of the intervener?
Mr. Chairman, just a couple of questions, just for clarification with Mr. Hill. Mr. Hill, you said you reviewed the application materials. Did you review the letter issued by the Department of Growth Management Services that said the application was deemed sufficient for review?
Are you talking from back in the 80s?
I'm talking about 2024.
No, I did not review that because again, that's not what's on trial here. It's this master plan.
Well, there's nothing on trial, but you made testimony to the board that there was insufficiencies and that we did not submit the appropriate documents and information to do an appropriate review. Mm-hmm. Are you contradicting and saying the staff lied?
I'm going to say this. Again, I don't know, but all I know is that when I submitted my request for the application, I did not see a landscape plan. And then as you see from the testimony given from county staff, there's no geotechnical report that is on file that is current. Because again, soils change. So I'm going to say that judging by what I have seen in my request from the department, that I believe the application is not complete and does not meet the guidelines of the Land Development Code.
Thank you for your opinion. Under section 5600 of the Land Development Code, are you familiar with that section?
Somewhat. You're going to have to read it to me.
In Land Development Code, it says, where practical, native species or species of recognized as a Florida-friendly landscaping should be planted.
Okay.
Does it say it must be planted, or does it say where practical?
I would say we're practical because that adheres to the policy in the Florida Friendly Landscaping Principles of right plant, right place. However, though, does that section override section 4303? Because 4303 is guideline for PUDs with general requirements.
This is my cross-examination, not yours. On the master plan, not the one on the screen, but we had the last slide in my presentation. Ma'am, could you bring to the very last slide of the presentation? It's the Exhibit A of the applicant's presentation.
Yeah, he wants his.
May I ask you a question while we're waiting?
Sure.
Are you familiar with the fact that landscape plans, irrigation plans are required to be submitted at the improvement plan stage, not at the PD zoning stage?
I would imagine that yes, that is true. However, though, if you are a developer who is trying to come to this community and win this community, it's not going to cost you an astronomical amount of money to submit the landscape plans at this time.
So in your opinion, it really comes down to cost to those people that create landscape plans?
No.
You create them before a PED can be reviewed by a public body?
My personal opinion is this, okay? If you have a project like Betts Farm, which is extremely controversial, your job should be to market this to the community as a good thing. And, if the goal is to basically show that, hey, this is something great, look, we're doing a great landscape plan with Florida-friendly landscaping, you can put some of the people at ease, but you didn't do that. And again, I'm just going to say this because I reiterate into the record, it is not that difficult to submit a landscape plan with your civil sets. We did it all the time in South Florida.
I'm not sure if you can read what's on the screen, but could you read the presented and proposed master plan, what item number 8 says?
Landscaping and landscaping design maintenance shall follow the principles of the Florida-friendly landscaping and yards program for the homeowners and existing and water use runoff. Yeah, you probably copied that from the Land Development Code and put it in your general notes. That's a very common practice.
That's copied exactly, and does that contradict the Land Development Code?
I would say this, that it acknowledges that that is a requirement, but again, the goal in submitting development is to prove beyond a doubt, because let me tell you, and I know this is controversial, people lie all the time.
Did you take an oath to tell the truth?
I did take an oath to tell the truth.
I take an oath to tell the truth.
You do.
Thank you, sir.
You do.
That being proposed and approved, it's approved today, and it's approved by the Board County Commission. Does the applicant, is they required to comply with that note number 8, which talks about requiring Florida-friendly, meeting all the criteria of that? Does it require that?
Well, I would say this, that yes, they would be required to say that, but again, how are we supposed to know that you're not going to be planting glossy privet, which is a known exotic, Category 1 by the Florida Invasive Pest Plant Council, and calling it a native plant? Or what's another one? Schefflera, which is umbrella tree. People say that's a good plant, but it's from Southeast Vietnam and it's becoming a problem. Or the most famous one is Mexican petunia. How do we know that you're not going to plant that and say, oh, it's Florida friendly, and then it takes over the wetlands because it loves wet areas? So again, you can put that letter up there all you want, but I want to see a concrete, bona fide landscape plan that proves you're going to follow that guideline beyond a shadow of a doubt.
Mr. Chairman, not to prolong this, but are you implying that the county staff would have incompetent people to review the landscape plans?
No, I am implying that the applicant is doing the bare minimum here and could do a lot more with this more complete application.
Thank you. One other question, though, not so much for Mr. Hill, but I'm not sure of the two individuals. Could you clarify if they spoke as experts or citizens?
They spoke as, well, Angela spoke as a citizen, and Ed has a background in engineering. He is also a citizen, but he does have relative background information.
I understand the background. The question I need to answer, and what was his Mr. name? Ed. Did Ed testify as an expert or not?
I would say that he did not testify as an expert. He does have the claim that he has been a civil engineer in traffic engineering for 40 years.
Yes, and I appreciate that, and I commend him for that. Unfortunately, Chairman, throughout his testimony, as a citizen or as an expert, I'm not sure, he continued to state, this is fact, he continued to state specific information about his opinion that it was insufficient or incomplete or not done. As a citizen, that is not expert testimony. It cannot be considered valid. And therefore, I just want to caution that if he's stating fact, I understand it. But he's telling you it's fact, and he's wanting you, under oath that he took to tell the truth, he's wanting you to believe that is in fact, and that you are to believe it. And I'm concerned about that, the way it was presented. Thank you, sir.
Thank you.
Question.
I actually have some questions for Mr. Hill, just a couple of questions.
You're part of the applicant.
So, just very quickly, Mr. Hill, you've made numerous assertions that the application is incomplete. Then you also spoke, well, in your opinion, just sort of echoing what Mr. Pigeon said. Either it's required by the Land Development Code or it's not. They've hit factor 8. It's on the application. It's on the PUD. So you stated as fact, oh, it's incomplete. And you say, well, they could put more. In your opinion, you'd like to see more. That's great. We'd all like to see different things in different circumstances. But it's my understanding from staff, and the board can ask their own staff. I can't ask her anything at this point. But that this application is complete legally. And if you want to ask questions, that's different, but this is a complete application, or we wouldn't all be standing here today. We'd be doing other things with our lives. This is a complete application, which is why it was brought by staff to you to be ripe to be heard. So where I am frustrated and asking you, your opinion, do you believe that your opinion is therefore law?
Opinions are not law, but however, though, they can set law, so I'll put that into the record. I'm just saying is this. People and civil engineers and designers scribble things on civil plans all the time. Matter of fact, I looked at a plan one time where they sent it to my county.
But you're not a civil engineer, are you?
No, I'm not. I'm a planner.
No.
They sent me a plan to review, and it was actually, instead of having Indian River County where I worked, it had Port St. Lucie.
What does that have to do with here right now? What does that have to do with here right now?
Civil plans are copy and paste jobs. I would not be surprised if that was put
We're
there.
wildly into speculation at this point. He stated his opinion as fact. He said the application was incomplete. It's complete. I'm not going to let him poison this application by saying that it's incomplete when it's complete. Okay, I'm done. But he's mixing in his opinion with fact and trying to blur this process and corrupt it.
Understood. You have 6 minutes left on your time.
I would like to address what was addressed to me about being speculative. I have 2 pages of what I read. I will be happy to submit this to the record, and these are all directly out of either the comp plan or out of submittals from Ardura or their consultants. Anyone who wants to accuse me of making speculation, they could read this report and find it right in whatever's submitted in the project memorandums. And also, I'd like to clarify, there was questions as to where we are located, where we live. I live in the neighborhood of Betts Farm. Michael was accepted, as it was talked about, on the data center. Who are the people asking that question? Are they from Citrus County? We've got a developer from out of the area. We've got an attorney from Tampa. We've got an engineer that lives in Ocala. But they're going to question where I live.
and I'm affected on a daily basis by this project. Thank you. Mr. Chair, we have completed our report. Thank you for your time. Thank you, Board.
Thank you. I don't even remember where we're at right now. Did the board ask the questions of the intervener? Did we get to ask questions from the intervener yet? Does anybody remember?
I believe so.
You did not.
No. Does anybody have questions for the intervener?
No. My apologies.
None? No. None? Okay, so I'm going to say it's 12:50. I want to take a 10-minute break.
10-minute recess, all right?
I have a doctor appointment 2:45. Try to come sit here. You're done. Just make sure he knows what to say.
All right, here we go. Give everybody a second to get in their seats, but I believe we were done with all of the questioning. We are to the point of public input. Am I correct? Everybody agree? Yep. Okay, so the public portion of the meeting will now be opened. If there's anyone present who would like to speak on this application, please come forward to the podium. As a reminder, individuals have 3 minutes and organizations have 5 minutes. When speaking on this application, please address the board. If you have any documentation that you want to be entered into the record, please provide a copy to the recording secretary.
Good morning, PJ Offhammer, Citrus County. I'm going to surely run out of time, so let me just start by asking that you deny this. There are a myriad number of reasons why. I'm going to try and get through some of them and tell you. First thing I would like you to consider is that in 1988, 1999, when this DRA was done, I was in my 20s, I lived and worked in a bikini, and I was skinny. Clearly, things have changed. The same with the DRI, and I would like you to keep that in mind, that comparing what was in the past has zero to do with what is going on now and in the future. First of all, this thing is too dense in comparison to, and any former allowances have no bearing and should not stand for consideration as regulations have changed. Open spaces, there are way too many DRAs and buffers, sidewalks, and other areas that they are claiming for use as open spaces. And I think by now, the majority of you know how I feel about open spaces. They are not appropriate. They get their credit for being wetlands and buffers and other things. They're not open spaces. We need actual areas in this community for homeowners with families to be able to recreate. The recreation area they have for 10 acres is going to be paved. Now, this is the only part of the paving that may be good because this is so dense that if you look at it, there's not enough room for parking for the people that live there, much less the people who will be visiting them. I have concerns with Swift Mud Permit 47924.1 issued on 6/5/26 for mass grading and clearing. I would like some clarification on whether this means that they can take sand and use it as part of their approval, if this is approved, similar to what they're doing over by Crystal Oaks. The other concern is that they could ostensibly clear-cut this, clear-cut it, leave it fallow and abandoned for 20 years if you allow them to have a 20-year extension to something that was already started in the 80s. Do we really need to have an application that's been going on for over 50 years? I say no. I say a 20-year extension is entirely too long, and we need to not allow that. We need to not allow the open space use. We need to not allow the extension of time. We have not discussed a tree plan. There's nothing about replacing all of the trees and the important things that are in that area. That is not consistent and should not be allowed. We've talked about so far the 100-year floodplain. Well, that's already been breached. I think it was Milton when Turkey Oak went underwater and everybody said, oh my God, what the hell happened? FEMA just extended it forward inland and it didn't even go that far. So clearly that's an issue that needs to be considered. Also the impact on the aquifer in the Kings Bay. There are I believe Mr. Pigeon was the one who said that they got all of the permits. Well, one of the permits that was required was actually waived by Swift Mud. I'm not sure why. I don't know if DEP was the one that was supposed to take that up, but it actually was not completed, and that needs to be considered.
Your time is up.
Okay, thank you.
Thank you.
I told you I was going to run out.
It's okay. I let you finish. I wasn't going to cut
appreciate
you off. No, he doesn't. Will now. Sorry. Next speaker.
Good afternoon. Amy Campbell, Azello. The biggest question I have is why take an important large acreage close to Kings Bay and convert it to housing. It has a function now.
So I think a park would be really great. 1,466 houses means fertilizer, Roundup, dog waste, running into Kings Bay, which is about 3,000 feet from this property. If we lose our springs either due to aquifer water loss or pollution, tourism would decline, which means our local economy would decline. And I recommend denying it. I hope that you would consider that. I just don't see any reason to go forward with it. I would hope that the potential buyer would look for some land that is suitable. There's lots of it in Citrus County, suitable for home building. Thank you.
Hi, thank you. It's my first time to speak.
Please state your name and your address for the record.
My name is Marina Whaler, and I live at 771 Northeast 6th Terrace in Crystal River, which is 1.4 miles away from Betts Farm. So I'm very qualified to speak about this, and I also have been there many times. Those who know me have probably watched my reels. I've been on this for a long time, and I've made a lot of videos about this. So I'll be quick. So first of all, I want to see the big picture. We don't need those homes in Crystal River. There are 600 plus properties on sale right now. I live on a block where all the houses are abandoned. They're trying to sell them. They cannot sell them. They don't sell. So who are you building those houses for? Are they for the rich New Yorkers who come and use them for Airbnbs? Or for the local residents? Are they going to be affordable? All we need here is affordable housing. And the buildings, the apartment buildings stay vacant right now after Helene and not used. People have literally go homeless because they have nowhere to live. And we are trying to buy those, to build more expensive properties. We don't need them in Crystal River. That's number one. Number two, the situation has changed since 90s, 80s, whatever you were talking about. We can't even talk about those times. It's different. We had Hurricane Idalia and Hurricane Helene, which brought unprecedented flooding. We had 3 feet of water in our house. And the Betts Farm area had more water, all of there, a little more east from us. And building there is not only reckless, it's evil. Because all those homes, if something like this happened again, they're going to be flooded, severely flooded. I don't think they're going to be built on stilts. Number 3, you can't build around the wetlands. You're going to destroy the whole ecosystem of Betts Farms. It's a huge wooded area with springs, with wetlands. It's a pine forest. For those of you who don't know, go and look at it. Look what it is. It's the most beautiful, thriving wildland right now. And there are deer, there are raccoons, gopher turtles, there are many, many species, and gopher turtles are now critically endangered, by the way. And native green anoles, lots of birds, and all of this is going to be destroyed. And honestly, I don't believe any of Dick's development saying that they're going to be some sort of green thing. Look at Crystal Oaks. It was clear cut. It was completely destroyed. All the forest, everything. There's nothing there. It's just devastation. Number 4, flooding from the rain. I have this much water every time at my home when the rain comes. It's crazy. If all those forests, we live near the wetlands, and there is a reason why it's not have been developed. Because if these areas are going to be developed, people will have up to a foot of water in their homes. And I'm a local resident. I don't care what these engineers or whoever say, but I live there. We know how it is. We had water in our house. Okay. Then, and the Turkey Oak is flooded, as you know, right? And I was really stunned by the lack of integrity when I listened to that presentation.
Your time is up.
Oh, sorry.
That's what that beeping was. I'm sorry. We just started it. We started it on you, but your time is up.
Okay, thank you.
Beeping.
Yes. No. Thank you. Next speaker. Come on.
Thank you all for having me.
Yes, sir.
My name's John Roberts. I live on Oak Street. I'm right there in the top of the picture. I've lived there for 20 years, and I'm a retired wildlife biologist, and I worked at Crystal River State Park as a volunteer for about 8 or 9 years, helping with the wildlife biology programs there. I'm a member of the Crystal River Boat Builders. You may have seen the boat that's out in front of Paddletail. We built that. I'm adverse to the usage plan for the building here. The reasons are my myriad. Traffic is one of the big problems. I think they mentioned it about the bottleneck on Turkey Oak and 44. With an additional 3,000 more vehicles, it would be incredible. It'd be worse than Los Angeles. Water supplies, I'm not sure how that's going to be handled, but more importantly is the water, is the natural resources. I have a whole big thing about gopher tortoises. I'm terribly sorry, and I could go on and on and on about it, but they're keystone species, and they are endemic in the area, and they are very threatened at this time. To build a large property development like that would be it would just kill them all. That's all there is to it. For an example, if they have a 20-year plan, let's say there's a block of property just across from Dunkin' Donuts up here that they have a plan for. They clear cut the whole thing down to bare grass, and nothing's been planted there, nothing's going to get used, and they're going to work on it now for umpty-ump years to come. I have a very bad feeling that this is what's going to happen here. Anyways, I would urge you to please consider either severely limiting the development of that property or denying the proposal. I'm the one that wrote this big, long, dithering letter to you the other day, so you probably got most of my coverage there. Anyways, thank you very much for your time, and I wish you the very best. Have a good day.
Thank you, sir. Who's next?
Hello, thank you for listening to us. My name is Rachel Irvin. I live right off of Turkey Oak on North Bay Avenue in Crystal River. I am less than a half mile as a crow flies and the water runs from Betts Farm. So as the growth has already put our county at a loss of water and limiting, you can't wash your car, you can't do this, and now the infrastructure that is, I don't think is going to be able to tolerate more growth. I can't understand why this property has to be developed as housing. There, like the other two have said, we have so many houses that are already empty. Some of them are in the flood zone. They're not going to sell. These people they think people are going to rush in here to buy these houses that cost way more than what they're worth. They're not. They're going to sit there empty. And we have now overdeveloped this beautiful farm area. Another bad thing about the development, they're talking about it coming out on Turkey Oak. I am right up from Citrus behind the old mall area, and the amount of trucks, the dump trucks, that come in off of 19 and come down come down Turkey Oak, turn left onto Citrus. They are loud. They are really overly loud. They're not supposed to start till 7 a.m. They start most of the time at 6:40 because I sit on the back porch and listen to them. And there's at least 600 of them a day, all day long. So how is that going to affect the poor infrastructure, which wouldn't be poor if there weren't so much traffic on it? But just as Commissioner Bramblett said, it's going to get worse, and that road cannot handle more. So then there's all the wrecks that come off of Turkey Oak and Citrus. There's all the wrecks at 44 and Turkey Oak, from all of them piling up down there trying to get through that light before it changes because there's so much backed up. So I've also, if they're going to develop that, and they said 46 to 50% impervious, that's more concrete. That land is soaking up a whole lot of the flood. Where I live had not flooded in that 100-year plan. My house was built in '86. It had never flooded. Helene came after they put in the RV parks, raised them all up. Where'd that water go? Oh, it didn't go in the RVs. No, it ran down into our little funnel. And we all flooded, which we should not have. And they keep building up. These houses are going to go up. They're going to be up. They're not going to flood. Nope. Where's it going to run? Down to our neighborhood, just like it's doing right now. So more concrete is not good. The sinkholes. Anyway, thank you very much. Appreciate you listening.
Thank you. Next.
Good afternoon, Joe Papp, Crystal River, 23 years. I'm not going to waste a lot of your time. It's been said, so I'm not going to reiterate. But I've talked to several BOCC members. So where their obligation stops, handling the extra traffic on the road, Crystal River has to pick up the rest. And just so you know, right now, we don't have any money for it. I don't know what the long-term plans are. But honestly, that's not a good place to put high-density housing with everything there environmental. So, I mean, I don't know that this can be stopped at that point, but it should be addressed. And if flooding does occur, whose responsibility is that to the other homeowners? Is it the developers? I mean, once it's done, it's done. And yes, it was brought up about the interchange on Citrus Avenue for the Suncoast. Well, you know, Turkey Oak is going to be a major ingress-egress route. It won't be able to handle it. As it currently sits, it can't handle it. But if Crystal River can't afford to make sure the road's high enough to get out of the floodplain so it doesn't flood and people have to get out, or either way, I don't think it's ready. I don't know what you guys have worked with the county on to kind of work through the whole thing long term. I don't know if they're going to develop it in 5 years or they're going to wait to the 20th year. So the other question is, how long will it be? How long do they have before they put in all the things that they promised? So, you know, without all those tangibles, I don't even know how we can come up with a decision here. It's the long-term effects that we have to worry about. The short-term effects probably will be minimal, some extra traffic. But as time goes on, I mean, look what's happening in Citrus County. We're $44 million behind in paving roads. So where do we go from here? Thank you.
Mr. Papp, can I get a yellow sheet from you, please?
Podium by the door.
My name is Chuck Utterly. I live in Inverness. The Citrus County still owns the property. Betts Farm was originally intended to be a park when the property was transferred to the Tamposi family in Citrus County in '03. Citizens have been calling for this property to be utilized as a park for decades. According to Citrus County comp plan, Betts Farm would fulfill a goal number 2, provided a variety of parks, recreational facilities, programs, and open space area available to all residents and visitors of Citrus County. A proposed subdivision by a developer that has no set closing date with a requested build-out date for 20 years is not beneficial to the residents of Citrus County. Specifically, Objective 2.1, the county shall periodically review its current facility inventory to meet the needs of the population through year 2040. Betts Farm wouldn't even be built out before then. That is, if it isn't minded for sand and destroyed to the state that needs a FDOT for Suncoast Parkway, Phase 2, 3.A and 3.B. The developer's storm management plan for Adura states that Betts Farm is a mass grading project for future residential development. No roadways, water, or sewer are proposed as part of that mass grading project. Connect the dots. The local community has been calling for Betts Farm to be a park. I believe it should be a preserve. I attended University of Florida, IFAS, down in Pinellas, and we toured Whedon Island Preserve, Brooker Creek Preserve, Boyd Hill Preserve. I believe Betts Farm should be a preserve. Thank you.
Thank you, sir. Next speaker.
Hi there, Nick Giordano from Hernando, Florida. In 2003, this piece of property was given in exchange to the county as impact fee credits for other projects by the Tamposi family. While nothing was put into writing, it was suggested that the land be used for recreation and conservation by the developer at the time. From what I've read, the county even started planning Betts Farm Neighborhood Park, which would have been super cool. But then years later, the county deemed Betts as surplus land and started looking at selling it off to various bidders and developers. I didn't hear anything about any sort of ecological report that had been submitted. What kind of endangered wildlife is Betts Farm home to? Before a potential sale happens, we need proper reports and surveys. In the applicant's concept plan map, there's a small little section titled "Probable Wetland Impact." I think you, Mr. Bramblett, brought it up earlier. That it's not present in the legend and sort of hidden on the map. What kind of impact, how much, and why are we building on this little section that has potential harm to the wetland? From an ecological standpoint, this area is very critical to the health and well-being of Kings Bay, which includes Three Sisters Springs. This area is a high recharge area. What seeps in as stormwater, residential runoff, etc., comes out at Kings Bay. With 1,000+ homes, potentially being built, the amount of pesticides, waste, and vehicle traffic, the degradation of wetlands and water quality is inevitable. We need this land as essential flood mitigation. We're already seeing new flooding all over the county and Florida. Do we want more neighborhoods to deal with this flooding? And not if, but when a strong weekend storm happens. This is currently county-owned land that was given to us, and it provides a huge ecological benefits. It belongs to the public, it has been through multiple failed deals in the past, and it should remain in public hands to be used as conservation land and a county park for future generations to enjoy and reap the benefits of. I request you recommend and deny this application. Thank you.
Thank you, sir. Who's next?
Jessa Williams in Crystal River. I live off Holiday Drive, and I am one of those residents that will be looking at the backside of those townhomes in that corner. I'm about 100 feet from that property line. I'm here today to oppose any development approvals of PUD 2733. I and all of the local residents living directly off Turkey Oak and its side streets would be gravely affected by traffic. You're talking about adding 3,000 more cars on this road daily. And widening the road will not fix the issue we would have pulling out of our driveways in the 14 side streets along Turkey Oak. Another major issue that we must keep discussing is our declining aquifer levels. More development in this area poses well water quality issues and long-term issues such as wells drying completely and the ever-looming threat of sinkholes. Remember the entire excavator that just fell in recently? Since the construction of Highway 589 in this area, I'm already experiencing water quality issues, now changing my filter 10 times more than I've had to in previous years. Please consider the quality of life in this area for existing residents. Please consider the strain on classroom sizes for the nearby schools. Please consider our time that we have to take to be here protecting what we love. Please consider the reasons that Bravo Land Group requested a continuance and then withdrew it today because I almost didn't come. Please consider this is not 1988, it is 2026. And Bravo Land Group is no more entitled to this property than the citizens of Citrus County. They took the same risk investing into this area as we all did purchasing our homes. We don't want their donations for conservation. We want actual conservation of all 349 acres.
Thank you.
Thank you.
Anyone else?
Landy, Dunellen on the citrus side with Sierra Club. We have a letter on file for 5 minutes. And first thing I want to say is to acknowledge and thank you all for your service to the community as volunteers. This is a big job and it's not getting any easier. So I agree with the previous 4 speakers. This land is perceived by the community as having been intended for conservation based on the Tamposi Agreement. Mr. Tamposi was an expert in floodwater and failed to get the permits to be able to proceed with that development, as best my understanding is of it. And also to keep in mind that the county still currently owns this land. It's not owned yet by the applicant. A key element that's been talked about is the conservation of wetlands. However, I did go in and find the permit for from SwiftMud for the grading. The permit that's been allowed is not for overall development, but it is for land clearing, grading, authorizing stormwater management system serving 348 acres in a mass grade project. This includes the creation of berms. My point is yes, they're conserving wetlands, that's commendable. However, the running of this equipment at this scale is going to ineffably change the stormwater flow, the conditions of the land, and potentially put neighbors at risk with, depending on where these berms are put, they're going to change the flow into the Kings Bay First Magnitude Spring, which is through Florida Department of Environmental Protection and their Basin Management Action Plan. That is a protected spring zone. That is not discussed anywhere in the application. There's no hydrology studies, geohydrology studies, environmental impact studies from those agencies, and the impacts of this project will affect the flow into Kings Bay. One of the things that the SwiftMud permit does say is that the project is located in a discharge in a watershed of an impaired water body, meaning Kings Bay. Basin Management Plan does show it impaired for nutrients because of septic tanks. The county is spending hundreds of thousands, eventually millions of dollars in getting match dollars from the state to address that nutrient nutrification. This plan makes it sound, this permit makes it sound like the nutrification is coming from Betts Farm, which we know it's not, and that this project will be improving water quality, when in fact, I thought that was a cat. Me
too.
When in fact, even with the stormwater controls that they're prescribing, and kudos to the developer for having like wetland retention areas, that's good, but in this case, not sufficient, because at this level of density, the stormwater system will gather some of the pollution, but you're adding pollution from development. Somebody mops their floor out the back door with the wastewater, spills something at the barbecue grill. This many houses, that kind of pollution coming in and percolating through pervious surfaces down into the aquifer will create a net degradation over years and time of the property that doesn't exist now in the condition that it's in. I've talked to people that live there, and they said absolutely that land is not destroyed. It's beautiful, covered in trees, and the value, just for a conversation that's outside of this county, but the value of those ecosystem services over the 38 years that that land has been there is more than $66 million. People that do ecosystem economics, $5,000 a year in ecosystem services. That means clean water, clean air, heat dome mitigation in a heavily developing state. These are all things that are the bigger picture, but that's still tangible, submissible evidence in terms of what the impact is long-term if this development is allowed. I would ask that you please deny this, or at the very least continue it until we have more evidence of how this will be sustainable and very low impact, which is the argument that's being made, but I do not see that the argument is complete. Thank you very much for your time.
Thank you. Next speaker, please.
Maxine Connor, Homosassa. Thank you for your service. We have more springs in our area
You
than
need 3 or 5 minutes.
3. Thank you. Speaking for myself, thank you. We have more springs in our area than anywhere else in the world, and most of them have been declared impaired by the Florida Department of Environmental Protection. Kings Bay and Crystal River are officially listed as impaired by that organization. This project is in the recharge area for Kings Bay. 1,466 total units means more lawns and more impervious surfaces, meaning any runoff of pollutants such as fertilizer, herbicides, and pesticides from lawns, and pollutants from roadways and other impervious surfaces. These pollutants will end up in Kings Bay and the Crystal River, and finally, the aquifer below us that supplies our potable drinking water. Natural vegetation such as trees, bushes, and other vegetation that absorb rain and prevent flooding will be cleared, and drainage retention areas will be installed. Some pollutants get filtered out as water sinks down through these drainage retention areas, but drainage retention area ponds are not wastewater treatment plants. Wastewater treatment plants filter out specific chemicals before returning water to the groundwater. In a letter dated March 9, 2026 from SwiftMud to the applicant in regards to Betts Farm mass grading and drainage application, it states that SwiftMud has completed its review of the application for environmental resource permit. Based upon review of the information you have submitted, the district hereby gives notice of its intended approval of its application. And in the body of that letter, it says that the drainage system provides a net benefit. But my question is, how can a natural area be cleared and impervious surfaces added and pollutants added and a drainage system added? How can that provide a net benefit? You are comparing it to a natural area with trees, bushes, vegetation, a natural area that absorb, all those roots absorb rainwater and floodwater. So the natural area, as it is, provides a net benefit. Also, I just want to say that a lot of people, I think, thought that this issue would be continued, and I think that if they did not think that, they would be here and you'd have overflow rooms full. And that's my comments for today, and I thank you very much for your patience and for your service as volunteers doing all that you do.
Thank you, ma'am. Next speaker.
Hi, Sandra Slowey, Hernando. I agree with Mr. Hill and the Betts Farms needs Florida-friendly vegetation and thoughtful conservation, not more development. Recently, I bought the empty lot next to mine that had vegetation on it. When I first started working on it, I realized and was amazed at how much of it was non-native and invasive. It took a tremendous amount of time and energy to remove it and restore the natural Florida vegetation to that property. And I would be afraid that if non-native plants were planted on this property, the same thing eventually would happen to that. We also have to consider what happens when lawns and landscaping are treated with fertilizers and herbicides and pesticides. Those chemicals can make their way into our water system and ultimately threaten the very natural resources we are trying to protect, like Kings Bay. I haven't lived here for that many years, but Betts Farms has a history that matters. I heard that in 2003, the Tamposi family transferred the property to Citrus County in exchange for impact fee credits. Now, I didn't hear the lawyer mention that. All that I kept hearing was everything has been this way since 1988 with the building permits and things. But I did hear that it was given to the county with conservation and recreational uses in mind. So I don't understand why that's still not in mind right now. Once the Betts Farm is covered with houses, roads and driveways and lawns, We can never turn it back to the way the natural land that it is right now. Citrus County, I know, is growing rapidly, and every remaining piece of natural land becomes more valuable, not less. Betts Farm can protect wetlands, provide natural drainage, preserve wildlife habitat, maintain green space, and give future generations something that development can never replace. We don't need to sell our children's future for a one-time payment. So the question shouldn't simply be how much can we get for Betts Farm? It should be how much natural land can Citrus County afford to lose? Let's preserve Betts Farm as a place where Florida-friendly vegetation, wildlife, wetlands, recreation, and conservation can continue to benefit our community for generations to come. Thank you.
Thank you. Anyone else?
Hi, Tracy Duncan of Lecanto. I thank y'all for your volunteer time that you give our county. We sure do appreciate your input and trying to help our cause. I just wanted to, I don't want to repeat what's already been said because it's been said numerous times, but it's very beneficial that y'all please consider it. There's been already so much land lost, we can't continue to keep losing land because our water is important. I really don't want to have to depend on city water as time goes on because we lose our regeneration system for our cleaning our water for our wells and our streams and so forth. I'd honestly just like to make a plea to Bravo if they would please consider withdrawing their application. Maybe consider preserving this as a reserve, you know, for the land, and consider somewhere else developing. Let this be our, you know, our piece that stays where it can continue to regenerate our water system and what little wildlife is left there and so forth. It's so important. I mean, we're honestly just losing too much green space here. And our water is essential. It's a very essential thing that we need for this community. And again, I don't want to have to go to city water. I'm originally from Homestead. We used to be farmers down there, and we moved up this here way because of the pristine lands that we have as far as the green space that we once had and that we're fast losing. I don't want to see us become a Miami. I don't want to see us become a Tampa, and that's what we're honestly slowly becoming as. We're losing what most people bought land here for and wanted to, our retirement community. They plan to live out their lives here in the beauty that this country, this, you know, Citrus County had to offer. We're losing that for them, as well as our children that are growing. I have 19 grandchildren that are growing in this area. They love it the way it is, and they're very saddened themselves as seeing us lose so much green space, our agriculture land, as well as our ranches. We're losing it. So please, Bravo, if you'd please consider donating this back or conserving this, you know, to keep it as it is, to keep our waters pure and as well as our wildlife around for our manatees and so forth. Just please stop building. Don't use this along our coastline. There's interlands that we can go to. So please just stop. Thank you.
Thank you. Anyone else?
Good afternoon, Commissioners. Paul Darty, 3481 West King B Street. I've got a couple of concerns from what I've heard here today, or what I haven't heard, you might say. One of them was that it was mentioned that the sewage disposal system that goes from this place that we're talking about to the Meadowcrest facility was begun, I think he said, in 1989, and it is currently being used by the county for others. My question, if you would, is it currently having enough capacity to take the people who are currently using it plus the ones they plan to build homes for? And does Meadowcrest, with all its previous commitments, still have the capacity to do this? That might be something you want to look into before you say A or nay at something like this. Another little concern I've had is that the central part of the county with the BMAP program, everybody's putting in all these nice little aerobic systems to get rid of all this nitrates that are supposedly winding up in Kings Bay and the Springs. Imagine 1,500 homes with 1,500 sets of True Green Chemlawn going into the ground right in this location. And imagine what that's going to do to the nitrates in Kings Bay. Thank you.
Thank you, sir. Anybody else? Last call. Closing the public portion of the meeting. Bringing it,
He gets
rebuttal?
Yep.
Rebuttal?
15 minutes.
15.
Up to 15, yes.
Mr. Chairman, don't really have rebuttal. Looking for factual testified information, and there's really nothing to respond to. Just keep in mind that this is the PUD process. The application was deemed complete. It had all the information, which included the history of information I spoke about before, which were environmental studies, socioeconomic studies, tree preservation studies, on and on traffic studies. It's all part of the record, and it's available to the public. Lastly, the second stage of detailed improvement plan submittal to the county is when all of the construction details are reviewed for trees, buffer, road intersections, landscaping. All that is done at the improvement plan stage, which is the next stage. There's a question about soil borings. Just want to point out there's extensive number of borings and soils and geotechnical work done. That's all on file at the Water Management District. They have the experts. They're way more than any of the experts in this room, I believe. They've deemed this thing, as you heard from one of the citizens, that it was complete, it was accurate, it was a net improvement, and that's based on the detailed engineering design that's been done to date to prove that this is not a degradation to the environment. Thank you.
Bringing it back to the board.
Sir,
Oh, I'm sorry.
A little bit of time. Yeah. No, just with a quasi-judicial hearing, I just always like to close by thanking the board. This is volunteer. This is not a good time, all day, but it's important. It's important to get all the facts out. A quasi-judicial hearing, the evidence is supposed to be competent, substantial evidence. Pure speculation or opinion, we've heard some of that today, is not to be weighed by a quasi-judicial board, which this board is. And so that's just a reminder I throw in at the end of every hearing. And really just want to thank you for your time and wish you good luck on this one. Thank you.
Mr. Chair, I'm sorry. Each party gets 5 minutes closing. I don't know if that was Mr. McAteer's closing or part of his rebuttal.
I don't have any additional rebuttal. I've got a 40-year engineer who's spent his entire life, professional life in Citrus County. I'm going to lean on him. Thank you.
Thank you. Staff?
Staff has no closing. Thank you.
Mr. Hill?
5 minutes.
5 minutes. If he needs that much.
I'll say one thing, and then Ed's going to say one thing. One thing I want to say is this, is that, again, was it after review of the application, we believe it is not complete. Again, that power sits with the board, and I can tell you all right now, the community has your back. If you have to make that tough decision, we thank you for your time. And I'll pass it to Ed to give his last one statement. Thank you.
We're talking about things like tree management plans that were supposedly approved 20 years ago, and we have the FDOT has come in along Citrus Avenue. I don't know how often you folks get up on Citrus Avenue. You guys need to take a ride up there. All the 100-year-old live oak trees have all been burned. They were burned all night long, about 1,000 feet from my bedroom. You guys need to go take a look at that. So if that's what they consider a complete tree management plan, I think it sucks. And there's also a thing in the 1988 that book that I quoted. It was the Citrus County Book 781, 2158 page. There's a clause in there about over $1 million, $1.6 million. It was either in
contingency money or something that was supposed to have been paid, and that all seemed to disappear. All things that were supposedly approved 20 years ago, they seem to disappear now. But I'm being accused of being speculative. Those are the facts. And here's the facts that I spoke on today as well. Thank you very much.
Can't accept anything from a party today, I'm sorry. You can turn it in for the board meeting? Yeah.
Okay. Now, we're bringing it back to the board.
Mr. Chairman,
Mr. Gilbert.
I want to go ahead and throw out a motion, and let's get this conversation on the way, if that's okay with you for a purpose of a motion. The Plan and Development Commission finds application number PUD 2733. I think I said that right? Yeah. Inconsistent with the Citrus County Comprehensive Plan and Citrus County Land Development Code, and this board recommends denial of the application to the Board of County Commissioners based on the evidence and testimony presented and the staff report and conclusions regarding this petition.
Second.
We have a motion to deny with a first by Mr. Gilbert and a second by Mr. Barmez. We'll bring it to the board for discussions on the motion. All right, Mr. Barmez.
All right, I guess I'll start. First, I'd like to start by saying at the beginning of this meeting, I had no means that I was indicating the county or the applicant for the Pine Ridge did anything wrong or out of order. The order was written by the judge. It was a court order and not an opinion. It was his order. I received that yesterday. Yesterday after I received it, I had already went through the package for this application. In no way did that hearing have a bearing on my decision on this application. I based my decision on a lot of things. One, I'd like to start with, I do believe the application is incomplete. I don't think you can bring an application to the PDC in Citrus County with a half-hearted conceptual plan. And I say that because I look at the plan, I see 8 wetlands noted with no mitigation to follow. I see 5 unmarked areas on the conceptual plan. We don't know if they're DRIs or DRAs. We don't know what they are. They're just green little circles on the conceptual plan. So it tells me that they probably did no kind of wildlife studies, no traffic studies that I see, no geological studies was in the package, no stormwater in the package. Those items are important why we make decisions. That's why we're here. It's to make a decision. And it's up to the applicant to bring the answers to us. Present your case. You don't go to a court with no evidence. You just to show up with just a little bit of stuff. That's what I believe happened today. I also believe that the letter that was sent to the county attorney yesterday from the applicant stating that they were going to ask for a continuance today was kind of a, we're going to do it, but really not going to do it, because I'm going to change my mind in the morning so all their county people can't come in here and make an opinion and voice their opinion. And that did aggravate me this morning, because there's thousands of people that probably would have came here and filled this building up. But the applicant took that away from our citizens, and I love our citizens here in Citrus County. I believe that the impact that it's going to have on the traffic is tremendous. 3,000 plus vehicles on Turkey Oak, not to mention the additional walkers that's going to be going to school and to the shops around there in an already highly trafficked area. I believe the wildlife, all the environmental concerns. I've never believed in a zero lot line, including pools. So there's just, and I can go on and on, but I don't want to, we've all heard it. And what we didn't hear, the applicant, in my opinion, gave us nothing but the only option that they left us It's speculation. Because you didn't provide the information, so we had to speculate, kind of figure out read between the lines, and that's not what we're here for. We're here to support the county and support the people. And that didn't happen in this application. So I will not support this application.
Thank you, sir. Mr. Shara.
I'm not, excuse me, I'm not going to support this application. I'm not going to speculate on the thoughts and processes that may have gone on over the last couple of days, and I don't think it's appropriate for us to speculate. I think what we need to do is focus on the merits of the application as compared to the comprehensive plan and the LDC. I realize that in the timeline of development, there are certain periods of time where certain kinds of documents are brought into the system, and as time goes on, more definition is provided. That is the way the system works. However, with a major development of nominally 1,400 plus homes that has been in concept for quite a while, what I don't believe is sufficient is that the level of quality of documentation should have been greater. Is it required under the county guidelines to be delivered at this point as compared to the period of constructability? You know, that's arguable in this process. But when I ask questions of what are you going to build where, are you willing to make a commitment that the condominiums or the multi-story units would be located in a specific location? No, I won't make that commitment. I want interchangeability that gives me the greatest flexibility over the greatest period of time to put into any area what we need to put in. We haven't accepted that in the past with other major developments. The 20-year development period, we're just facing reality that there was a lot of flexibility in when that would get built out. I think, and so it's a judgment call, but in my judgment, 20 years for a development of nominally 1,400 plus units is way too long because it leaves things open-ended. And it leaves things open-ended for the people who live there. If you've ever lived in a development under construction, you know what I mean. The general area, this comes down to judgment. Topography, wetlands, roads, karst, environmentally sensitive areas. This doesn't look to me to be a bad project. Clearly, I don't think there's enough definition. I think it's in the wrong place. And it comes down to just because you can doesn't mean you should. And what turned my head on this was the review and the research of the application, was going to that site, was trying to understand the wetlands and the wetland mitigation, not the buffers. Those are just prescribed in environmental regulation. But then the unintended consequences of having that much of a wetland area in this kind of concentration and intensity of population. The intensity we've talked about of the ISR. ISR site-wide of 50% is certainly an acceptable number on average given the guidelines under the LDC, but the intensity around 65 to 70% is way too high for this kind of site. For those reasons, and I'll let my colleagues speak and others, I will not support this.
Mr. Bozeman.
The way I see it, the options are very limited. Allow it to be developed, proceed with the conditions that staff has recommended. That's one option. Hope somebody with a bunch of money comes along and outbids y'all and buys it and places it in a conservation easement, because that is one of the last remaining pieces of property in the area that are very natural. I've never stepped foot on the property, but it looks like a pretty beautiful place. The other hope is the county decides to keep it and turn it into a recreational area. That would be probably the preferred option. I've got a lot of confidence in the gentleman that designed it. I've got a lot of history with Mr. Pigeon over the years, not directly but indirectly, and I've known him and I trust his ability. However, I just think this is the wrong place. No, nothing derogatory toward your attempts to do this. It's just the wrong place. I don't think the traffical roadways will support it. There's no long-term plan. Water and sewer capacities have not been discussed. Do we have the capacity at the wastewater treatment plant? I don't know. If it's in the packet, I missed it. But I agree. It's a good-looking development. I just think it's in the wrong place, guys, and I'm not going to be able to support it.
Anyone else? Mr. Facemeyer?
Thank you, Mr. Chairman. The history of the Betts Farm is very complex at best. Many people in this room know more details than the board probably. Nobody probably knows all the details. What's even more complex is the circumstances surrounding why we are here and dealing with this pending application. It's not our decision to make it's not our position to make a decision based on a desired outcome. We're here to make a decision based on the facts presented to us today. Along with Commissioner Chairman Bramlett, this is the third bite of the apple, I think, for us. We've been here long enough to remember at least two of the other iterations of this. And perhaps we voted in favor of this in the past, but today I'm not prepared to support this, and I will be voting against this application.
Ms. Murphy?
I also will be voting against it.
Okay. We have a first to deny by Mr. Gilbert, a second by Mr. Barmez. Any additional discussion? I'm not going to beat a dead horse. Everything's been talked about. It's late. It's 2 o'clock. Appreciate everybody's time and attention, public input. There are some things that are nice about this project, but there are some things that are lacking. The piece of property is what it is. We don't really need to talk about that anymore. With all of that said, all of those in favor of denial, say aye.
Aye.
Aye. Opposed? Motion carries unanimously.
And Mr. Chair, this has been set for the Board of County Commissioners on October 13th at 5:01 p.m. That's at the Commission Chambers in Inverness.
Thank you. Mr. Landon.
Yes, Mr. Chair. A couple items that get discussed in the community pretty regularly are the update on the comprehensive plan and the data center ordinance. I can kind of pencil in some updates on both of them. The data center ordinance staff is almost complete with the first draft. Our intent is to post that on the county's website the first week of September, and then provide a form that goes with it where people can share their thoughts, concerns, feedback. Some may think it's too restrictive, some may think it's not restrictive enough, and they can make our recommendations. Following the opportunity for the public to comment on it, our intent is to do a workshop with the BOCC where the board can hear public comment on it. And then once that process is complete, we will bring it to you for the first public hearing. So I spoke with the chairman of the board, and she felt it was important that we have an opportunity for the board to hear the public prior to any votes taking place. So we're gonna, and then we also felt it was important to have it posted publicly where everyone could kind of absorb it and digest it for a period of time before any hearings are had. So that's the kind of the penciled in process that we have. That will begin the first week of September. On a similar track, the comprehensive plan is being written, and those drafts are being delivered to us with questions to answer, kind of like some technical local knowledge that they're looking for. We're going to post those drafts on the Citrus 2050 website, and then they are anticipating having a public listening session in October. And that'll be an evening in this room, kind of like they did with the opening workshops, where they will post the drafts, give the community time to review them, absorb them, find what they like and don't like, and then we can meet here in October on an evening, and they can share that with the consultant. They will absorb that feedback, and then that website will also allow folks to email in their thoughts, concerns, and kind of create some dialogue. after they absorb the public's feedback, then they will take it to you next for the first public hearing. So both of those are kind of on similar tracks. I would anticipate delivery of those documents in September, and probably workshops and meetings starting in October, and then probably in November we're looking at maybe our first round of public hearings. So both are on track, both are on time. It'll be an exciting conclusion to the calendar year to have those projects hopefully getting finalized.
Just got a question. Would that be with the new board putting that in?
Yes.
Okay. That's all.
Quick question. I would like to recommend we have a public workshop on the comprehensive plan before we bring it to a public hearing and vote. It's going to be complex.
Sure.
It is the overarching document.
Sure.
So in terms of sequence, the preparer come in and have their public presentation, work in any additional modifications they make, and allow us to have at least one workshop and really work through the document.
Okay. I'll make that recommendation to them.
Okay.
Sure.
And just to add, both your meetings in September and both your meetings in October, we have 2 applications on every single one. Of course, there was 2 today, so it's not really a great judge, but I don't anticipate anything taking this long in the next few months.
Anyone else? Adjourned.
I don't believe you, Joanna.
What do you mean?
I don't believe you.